Hi, a very good evening to all of y'all. Today, let me tell you the plan. Today, we will be doing the part B, which is your 40 marks, which is your intellectual property rights of your ECIPL paper. The part A marathon I have already taken and I have shared it in the groups. You all can go ahead and start learning from there. And as and when I might give you breaks during the lecture, you can complete and knock off a few chapters from there as well. If you want other chapters also which I have not taken, you can get it from the dream batch. Okay, great. Now let me tell you the plan for today. I will be completing your part B, 40 marks. Okay, and here first you can go to my website. On my website you can see this scanners. Okay, the JT scanners, around 3581 3600 scanners have already been downloaded. You can download it and then you come to your scanner. So this is the ECIPL scanner where I have the past exam questions, okay, the latest past exam questions of ECIPL paper along with the model answers. So as and when I complete my particular topics, I will also go through the past exam questions, so we know we don't miss out on anything. Okay, so in your subject ECIPL paper, I will be covering a few chapters. I'll tell you what's the plan, and with me you can cover those. Okay, and whenever simultaneously you can study other topics also. Okay, you can keep your books open and start knocking it off the other chapters, so simultaneously get over. The first topic we will start is your Trademark Act. Okay, so we will be starting with Trademark Act, and this is the Trademark Act, the Bare Act. Just a second. Yeah, ECIPL here is going to open the module. So your job is to understand that you can easily complete your ECIPL is a super simple subject to clear and get good marks. What do you need to do? Part A, you complete it and keep dedicatedly 4 hours. 4 hours for 60 marks. I've covered most of the chapters. Most of the chapters I've completed. Okay, in depth. And now I will be covering your intellectual property rights. Intellectual property rights. Okay. Now remember, you can start it in the order that I am doing, so it will be easy for you also. Okay, the chapters that I will be covering. Okay, the basic chapter which is there, this could be done last. This I am not doing. Once you do the other chapters, intellectual property right, the basic concepts will be cleared. Okay, so you can cover this. I will be covering the balance chapters, and first I will start with Trademark Act and then I will do the other chapters. Your first chapter, 15th one, I'm not doing. It's going to be very simple. Based on these chapters only the introduction is given. Okay, now without further ado, let's start with our marathon. Okay, so I need a GTG in the chat box. GTG in the chat box. Keep the Trademark Act open in front of you. You can keep your modules open, your study notes, whichever it is. I will try to knock it off in a span of 40-45 minutes max. Okay, so you will know what is important also. So before I start, quickly in the chat box, am I audible, visible, so I can start and complete it? Okay, just write audible, visible. Keep your chapter open. By this time, I believe you've completed part A, lot of chapters. GTG, everyone, Sayyid Afroz, Vipasha, Pradeep, great. Sona, great. Let's start. Hi, so we start with the Trademark Act 1999. Now, before we start the Trademark Act, it is very important to understand which are the past exam questions. So we know that while doing the chapters, we have a deep focus on those topics also. So the first one they have asked is with respect to your section 11. Section 11, as it is the very important section which contains relative grounds and absolute grounds are, as it is very important sections. Section 11, I want you to note it down so that while doing it we will cover. Then there is one section 21ZG, okay, which talks about the definition of well-known trademarks. So well-known trademark has come. Then they have come something called as a well-known trademark again. Okay, repeat it twice. Then we see they have asked about trade secrets. Explain the concept of trade secrets. Okay, then this is about TRIPS agreement. This is a lesson number 1. Okay, which I'll take you through the background of lesson number 1 also, not an issue. Then we have patent. This is your Patent Act. Okay, so these are the questions that are there from your thing. Now let me mark certain sections important, which are important from while doing it. We will focus on them also. Okay, so we are doing your Trademark Act 1999. Okay, now in that, which all sections are important from exam point of view? Your section number 9, your absolute grounds for refusal, your relative grounds of refusal are important. Section 9 and 11, and 11 we saw also has come. Okay, then the next important section from here is your section number, okay, just a little bit of transmission and this, the range is important. What is transmission and assignment? 29 and 30 is important. Okay, so just note down this also. 29 and 30 is important. So all these sections, when we come, at least 4 sections should be by hearted by you. Okay, so section 9, section 11, section 29, section 30. Okay, simple sections. When we do, I will tell you. Chalo. Now we begin with the act. So let's begin with the Trademark Act. Now what are these? These are particular marks, or these are trademarks of their companies. So whenever you look at a logo and you can identify the original manufacturer, original trader, or the proprietor of the mark, it is called as a trademark. Okay, it is called as a trademark because they use this mark so that moment you look at the mark, you can identify who is the owner of the goods. So now we just learn the meaning. Okay, if I have to say what is the meaning of a trademark in normal words, okay, so trademark is any mark, any logo, any pattern that helps a business identify its products and services from others. So what is the job of a mark? Is to distinguish, differentiate that these are, if this mark is there, it is my goods, from other goods and service providers. Now when you do that, when a goods or mark has been put, it helps in ensuring that the products are of a certain quality. So when I buy an Apple product, people associate it with quality, and it also helps you advertise in a smaller place also. So every time if I say BMW, so just with the logo persons can identify, so it becomes very easy and distinguishable from everyone else. Okay, now we'll be doing which is important from exam point of view. Okay, and I will be giving you case laws also. So a trademark is a mark that, or a mark, a pattern, or logo which helps a company distinguish its products from others. A trademark has 4 functions. This is in general. It has 4 functions. What does it do? What does a trademark do? When you see a logo, McDonald's logo, it helps identify that these are McDonald's products and not anyone else's product. It guarantees a taste, quality, standard, etc. It helps you advertise much easily. Just by the logo, people will be able to identify the original seller, and it creates a image. From the screen. If you see, even our logo is there on where I'm sitting, just on my table here. Okay, if you see here, what is it? It's the logo of Jahangir Tutorials. If you see, the logo has a certain pattern. It is like a book which is enlightening people. And very interestingly, a particular logo will also include certain colors which are there are also covered. Now I want you to note it down and quote it in your exam. So this, some of the sections I want you to quote it, and one of this is here. So this you will write in exams. It is the definition of trademark as per the Trademark Act 1999. So your trademark is defined under section 21 ZB. Why ZB? Zubair for my name. Okay, just remember that trademark is ZB. Now, when you saw my logo, when you saw my logo here, what did you see? That a logo could be of not only just a mark. It is a mark which which helps me distinguish the goods and services of one person from the other, and it is capable of being presented graphically. Means on paper I will be able to show. So when you apply for a trademark registration, you say this is my business mark. While registration, you have to draw the mark, tell them which colors it is, which font size it is, what are the patterns that are there, how does it distinguish others, etc. Okay. So what do you mean by the trademark? We'll write the definition 21ZB. A trademark is a mark which can be presented graphically. Now see, since we are going to definitely write it in the exam, we'll study it properly. And what is the purpose? It helps us distinguish the goods and services of one person from that of the other. And very interesting that the trademark may include shapes, packaging, combination of colors, etc. So anywhere, even if you see the title, the thumbnail of this video, you will see that it is in blue, golden, white. This is our standard colors that we use across. So we try to maintain a brand colors, brand text, brand images. So obviously, companies like BMW, Apple, they have a certain set patterns. It's not only the logo, but it is also your packaging. You can even have a helps distinguish the packaging, the combination of colors, etc. Now when I say packaging means what? Sometimes even Apple's packaging is also differentiated. Okay, so that with the help of combination of colors. Simple. Now there are different kinds of trademark. Now we have understood the definition of trademark. Everyone, which is the section for trademark that we will write in the exam? What is the section for trademark? Section 21ZB. Okay, it defines ZB, defines what is a trademark. Simple. It is presented graphically to distinguish the goods and services and includes not only the mark but also the patterns, everything. Now the next is there are types of trademark. There are various types of trademark. So types of trademark. Now categories I could call it. I could call it as a categories of trademark. One is a certification mark. Certification mark which has come in the exam and it's important also. The other one is called as a collective mark. Collective mark. The other one is called as a well-known trademark. Well-known trademark. Okay, so we will be seeing what are these. These are the three important trademarks that we should know. Now a certification trademark. Now pay attention that a normal trademark is understood as a business mark where it is applied or put or affixed or used when you are buying and selling goods. When you are buying and selling goods and services, that is when you will put. But there is a type of certification trademark. So this trademark is applied, just write the word, it's applied by a certifying authority. Certifying authority. Okay, it is given by a certifying authority that they certify that the goods or the service are of a certain standard, quality, purity, okay, etc. So a certification trademark is not applied by the business owner. One, it is put by a certifying authority. Okay, and this certifying authority, this mark is put in addition to your trademark. It is addition to the trademark, the original trademark. So maybe if some food products, Amul food products are being sold, so they will put Amul and they will also put certain certifying trademarks. For example, the FSAI mark, the ISI mark. Okay, your B's for your, when you go to buy a AC, let's say I'm going to buy a Samsung AC or I'm going to buy a Voltas AC. So in Voltas is the Voltas written is a trademark, and on that certain certification will be given, like for example how energy efficient it is. Now this I can't just put 5 stars by myself. It is applied by a certifying authority. Okay, simple. So what is a certification mark? A certification mark is a mark certified by the proprietor of the mark. Means there must be an agency that must be owning the ISO marks. They will only put. Okay, and it indicates that the goods and services meet some standards such as quality, quantity, purity, manufacturing process, other attributes. Even like a veg, non-veg is affixed by the authorities. Okay, it is always certified by an competent authority. Okay, a certification mark may be used in addition to the other trademark. And one example, if you want to write, for example, which toothpaste you use, Close Up, Pepsodent, whichever you're using, that is the brand name. Dabur is a brand name. In addition to that, you might have on the back side a certifying authority, which is the Indian Dental Association. They will certify that the toothpaste is meeting certain standards of quality. Certification mark is completed. Concept clear? Yes or no? The definition is given under section 21E. Definition is given under section 21E. So a certification mark is a mark capable of distinguishing the goods and services which is certified by the proprietor of the mark. It distinguishes from whom? From those who are don't have the mark. Okay, that the goods are of certain standard, quality, purity. Okay, so if we take some example, the FSSAI logo. So if I'm having this, I know that the food products that I'm going to eat has meet certain standards. So it helps in the consumer decisions. Okay, now first type, important type of mark we have completed. Okay, now we will go to the other type. We have done till now the definition. We have done the definition. Now we did certification trademark. Now we'll do collective trademark. Now let's understand the concept of collective trademark. What is a collective trademark? Anyone knows? So a collective trademark is used by a collective group of persons. Means all of us will use it. Okay, not only by one, by many people, and only members of that institution can use it. So the best example is as we are becoming company secretaries. Okay, so we know that CS, this is a logo of CS. So this only a CS can apply this logo. Only a CA can apply this logo. The CPA can apply this logo because they are members of this institution. So this mark is collectively used by the members of that association. Sometimes if you are a member of Happy Club or a member of a Rotaract Club, so that will be used. So if you go to see what is a collective mark. So collective mark is a unique trademark, owned and used by an association of persons, okay, which set them apart from others. So main purpose is to set yourself apart from others. It is used by a group or collection of individuals as long as they are members of that organization. So collective mark is a unique trademark used by not one person, not one business owner, but by an association of persons. Okay. Now the definition is given under section 21G. 21G defines collective trademark is a trademark that distinguishes the members of an association from that of the others, which is the proprietor of the association from that of others. Simple. Okay. So the CS qualification logo we've seen. Okay, that is there. So the logo is there. This is the logo. This is your dream. Okay. So this is the logo of ICSI. And this is the logo for the members. This is called as a collective mark. Only all of us can use after we become a company secretary, and it cannot be used by anyone else. So what is this called? It is called as a collective trademark. Beautifully understood. We are done. Now we come to the third and the most important type of trademark. So one we did, I told you there are three important certification trademarks, collective trademark, and this is known as a well-known trademark. Sir, what is a well-known trademark? From the name itself, it has become well-known in the eyes of people. Now, I can't use the word well-known again, right? So, we will say that it is popular, it has become an integral part of the people, and people can identify this trademark. So, let's see. A well-known trademark. Okay, what do you mean by a well-known trademark? A well-known trademark is a mark with a considerable goodwill and reputation and has become well-known in the public. From the name itself, this has become well-known. So what if a trademark has become well-known? So then they say that even if it is not registered, okay, they have become well-known. So even if even if they are not registered, they can still ask for protection. Why? Because the public have now started to assume some trade connection between the mark and the goods. Let me explain. Very, very simple. Now, what is the logic is, suppose if there is a trademark which is registered. Now, for this you need to know one line. That does a trademark give you, if I've registered a trademark or if I've started a business, you think that it gives me universal protection? Answer is no. All the protections are territorial. Suppose if a business which is in USA, okay, let's say we are talking of a business in USA like Apple. Apple has not registered itself. Example, just take an example. Apple has not registered, or they have registered in USA but they have not registered in India. So for the purpose of India, they are unregistered trademark. For the purpose of India, they are an unregistered trademark because in India they are not registered. Now, if in India someone starts using the Apple logo and starts selling mobile phones with the Apple logo, saying that listen, they are not registered only in India. So then Apple can file a case saying that we have become well known, we have a considerable goodwill, and now people, if our mark is put on any goods and services, people will assume a trade connection, that they will assume that they are buying goods of USA. So such well-known trademarks will be given protection even if they are not registered. So what is the line? That well-known trademarks, even if not registered, can be protected and registered. So if anyone has not used if anyone has a trademark which has become very famous, now anyone uses, they can stop them in the world anywhere saying that listen, we are so famous, now if this mark is put, they all will assume that you're talking about me. So the definition is given under section 21ZG. Okay, what is the definition given under section 21ZG? How do you define a well-known trademark? So a well-known trademark is a mark which has become substantial part of the public. So they have now started to identify this mark. This mark has become so substantial, so famous in the eyes, in the minds of public, that if we use this mark on any other goods and services, then people will indicate a trade connection between them. Okay, so what you will write, that a well-known trademark is a mark which has become so substantial in the minds of the people that if this mark is applied on any other goods and services, people will assume that it is of that original owner of the goods. They will assume a trade connection with the original owner of the goods. Clear? So let's take for example another company. Let's say we have Tesla. Now Tesla is a USA company. Let's say they have not registered their brand for trademark in India. Now there is another car manufacturer who starts using Tesla logo. So Tesla identifies this and then Tesla will file a case. So this car company will say, listen, you are not registered. So since they are not registered, they will have to prove something. They will have to prove that they have become well known, that applying this logo on any other goods and services, people or persons will assume that it is that of the original brand owner. Clear? This is what we will right? To look at this, they will look at various other things like so if a trademark is registered, can anyone use it? Answer is no. The owner can directly file a case for infringement. They will directly file a case for infringement. Owner will say that my registered trademark is violated, misused, applied on some other goods, I am filing a case. If the trademark is not registered in India, okay, then they will have to file a case of passing off. Sir, what is passing off? Passing off is basically filing a case. Passing off means unregistered trademarks has been used and this person is trying to prevent them from using, because passing off will only be allowed. Case will only succeed means if the mark has become well known. So please write this down, that if a mark is not registered in India, then the proprietor of that mark can file a case of passing off if any person is using that trademark, using that mark which is not registered. However, the courts will protect this mark only if it has become well known. Now, how will you prove well known? By the application, by taking some inquiries, by studying the market, etc. Okay, by the customer base, etc. Okay, so to determine whether a trademark has become well known or not, you will have to look at the public inspection, number of people that are using it. Okay, how long is this mark being used in a geographical area? If they have succeeded in other countries, successful enforcements in other countries will be seen. So another example I will give you, imagine if Google is not registered in India and someone is using the logo Google. Google will say that, listen, I'm sorry, I'm not registered here, but I have become well known, so I can file a case of passing off. Simple. Okay. Now, there was a very good case which you can quote, Whirlpool and N.R. Dongre. What did he say? A case study for this. Now, the Whirlpool is a famous brand. It is not registered in India. So, a plaintiff in India, there was a person in India, started using the same mark for washing machines in India. So, Whirlpool is not an Indian brand. It was not registered in India. And then someone else started using the machine in India with that logo. So, their plaintiff could not file a case of infringement because they were not registered. But the plaintiff can still file a case of passing off, and it will succeed if it has become well known, that they will say that, listen, we have become so well known in the eyes of people, it has become so substantial in the minds of people that we have trans-border reputation. We have a reputation which is going across borders, and this will be done after market inquiry. So you can write rule to apply for this. You have to well-known trademark can be applied on rule 124, okay, of the trademark rules 2017. So person will have to apply in form TMM. Okay, so this is the form number to apply for a well-known trademark which wants to be registered or wants to get protection. Okay, then all of this will be seen, and then if it is fine, it will be registered. Okay. Now, understand one line, that one more thing is, when a mark is registered, okay, now the owner of the mark, okay, so we are talking about trademark which is registered. So this is a registered logo, that if your trademark is registered, you will see a R written there. Now, when a trademark is registered, that time the owner of mark, always a owner of any intellectual property rights will get two things. One, they will get positive rights, and second, they will get some negative rights also. Sir, what are positive rights? What are negative rights? Positive rights is to do something, and negative right is others. So stopping others from using is not to do something. So you can stop others from doing something. So what all, if I have the mark, I can either sell my mark or I can assign it. Assignment is also there. Sir, what do you mean by assignment? Assignment means the to transfer your right. Transfer your right. Now obviously, if you go to see what does Tata do? So if you go to see Tata's, what do they do? Tata Chroma, Tata product, Tata Starbucks. They are lending their name. They are lending their trademark. They can do it for monetary purpose and earn money. Negative mark is if anyone is using the Tata logo, they are can restrain them. So a permitted use obviously means can use themselves or can allow others to use it. Simple. So the person, now pay attention to this. If there is Tata's allowed Starbucks to use their logo, right? Obviously they must have charged some money. Tata must have charged royalty. Now here in this case there will be a registered owner and there will be a registered user. Okay, so we can say registered owner or proprietor, and the other one is a registered user. Now obviously to allow Tatas in, or when they are allowing Starbucks to use their name, okay, they would have given some kind of agreement, would have entered, royalty points would be written, signatures would be given, etc. Now here, can you tell me who is the registered proprietor of the mark? That is the original person who gave the application. Here it will be Tata's. And now let's say they have an agreement that Starbucks can use the logo for 5 years. So that also will be registered, okay, and will be informed. So this will be Starbucks. Okay, simple. So the registered user is a person who has been allowed by the proprietor. Simple. Through an agreement. Now, procedure for registration. Now, when we see section number 18, okay, what does it talk? It talks about procedure for registration. Before I come to that, let me tell you that even sound marks can be registered. Okay, so for example, when we have sound can also be registered as a trademark. So there was a Airtel ringtone, ting ting ting, or there have a song for Airtel that can be registered also. So even a sound can be registered. Let's see, simple. Now we'll see the procedure for registration. Very, very simple. So there is a trademark authority who you will apply through your application, and the process is same for all the intellectual property. Okay, now pay attention to this. If you want to register registration of intellectual property rights in India, so maybe it may be trademarks or copyrights or patents. Any of them, they have a common format. They have a common process for registration. So the process will be, you have to make an application. In the application, you have to give a complete details. For example, if it's a mark, you will draw the mark, you will tell the colors, you will tell who are you will tell your genre of business, everything. All the details will be given. Now, when you give to and always it's given to the registrar of trademarks who will register the trademark. Now, when I give it to the trademark authority, what do they do to make a publication? So it will be published by the trademark authorities, okay, in the trademark journals, in the patent journals, etc. So once it comes in the journals, then anyone wants to make an objections can make objections. Okay, so they can tell that if anyone feels that it is similar to them, so objections will be heard by the registrar, and after hearing both the parties, it will be granted. Simple. So this will be the normal simple little process, and then you have to pay your fees. Okay, now trademark is renewable, so every time you have to pay renewal fees. Now we look at that process. So who can apply? So a person who is claiming to be the proprietor of the mark shall apply in writing in the prescribed form. He'll give a single application along with the fees. Okay. And process I have told you, very simple. First, before doing the process, there will be a search. So you have to do a search yourself whether you want the logo or the mark or the name that you're using, whether it is available or no. So a name search can be done whether what I'm doing is allowed or not allowed. Okay. Now, second is submission of the form. So you have to give now it starts. Okay, before that you just do a self research, then you submit the form, it will be examined, then published in the journal. Then if oppositions will come, you will hear that anyone is objecting, registrar will hear, and in the end they'll have the registration. This process is common for all the intellectual property rights. First you do a search to see whether it is allowed. Then you make an application. That application will be examined and then published in the journal. Objections will come. After the objections will be heard, and then if it is the registrar feels that it should be registered, then he will go ahead with the trademark registration. Simple. Now the application that you make for all the particular the registration process, it could be electronic or physical. Okay, but nowadays most of the trademarks are all the application, 98% approximately, are online applications only. After doing that, it will be examined. Okay, it will be examined by the controller. He will prepare a examiner. He can appoint a particular examiner only. Means if the controller wants, he can appoint an examiner to create a particular study, whether it is correct, whether it is violating, etc. Okay, so he will prepare his report and then he will give his report to the controller. Sir, it is same for all? Yes. If you understand one process, all the other registration process of all the intellectual properties are the same. Okay, and after the examiner gives a go ahead, then there will be a publications and objections will be heard, and then after the objections it will be registered. Okay, and then trademark is valid for 10 years and then it can be renewed indefinitely. So again, once registered a trademark, it is registered for how much time period? 10 years, and after that you have to do renewal. Clear? Done. Now I told you two important sections that we need to know: section number 9 and section number 11. Section number 9 is about absolute grounds of refusal and section number 11 is about relative grounds of refusal. Means what? In absolute ground means they will just reject it. What nonsense! This is the worst possible kind of name that you can give. If you are using a name, so this is about, I am giving a name that please keep the brand name of I'm into the car manufacturing business. I want to register my business. They say register. I say my brand name I want to register. They say register, na. I say by the name of my brand name is car. So they say that car you are writing. So what others will use? So car, all these generic words are not allowed only for registration. So these are absolute grounds of refusal. Please note down the headings. You are done. So if any mark, so these cannot be registered. It's prohibited from registration. If it lacks distinctive character, doesn't have some speciality only. Okay. If I give apple for a brand of apples, so it is devoid of any speciality, any special character, not capable of distinguishing from other goods and services. So it will be rejected. Now, I want you to note down section 9, subsection 1, subclause A. I will ask you. Okay, please note it down. Second one is, it is descriptive mark. It is describing the business that you are doing. So it is a exclusive indication, okay, to the quality, quantity, purpose or the intended use. For example, I am saying fresh orange juice. You are describing your product. Okay, if I want to name my brand Shimla, now again you're trying to describe what you do, where you do, purpose, etc. So this does not have distinctiveness quality. Third, it has become customary in the minds of the people. Such words such as Kodak, etc. Okay, they have become customary or common in the use. So, which consists exclusively of marks or indication which have become customary. Okay. Now, only one exception is there, that if you are using any mark from all of this which has become well known before the application on its own merit. So Apple is there for phones and it has, let's say, not registered, but it has become automatically, it has become a substantial part of public. So then it might still be registered. Only one exception. Chalo, now you tell me what is the 3 points given section 9 subsection 1 A, B, C. What it is? So what is the A point? What is A? It lacks distinctive character. Okay, this is describing, it is describing, description of the goods and services are only being given, orange juice, okay, etc. And third is, it is become customary or it has become a common word. Hello, for example, hello is something very common, so you cannot use the word hello as your business name. Okay. Now WhatsApp, you will say, sir, everybody says WhatsApp had become WhatsApp. So I think is, it has become, if a brand has become well known on its own, then it can still be allowed. So customary, descriptive and distinctive. Please note, okay. And another thing, so section 9 subsection 1 contains 3 points: distinctive, descriptive and customary, DDC. Okay, DDC, section 9 subsection 1 DDC. It has become descriptive, it is a descriptive mark, it has become it lacks distinctiveness, or it has become customary. Next is section 9 subsection 2. The trademark shall not. So 9 subsection 1 is also there and subsection 2. Now 2 is very general, it is become deceiving the public, hurting religious sentiments, okay, containing scandalous or obscene matters, prohibited in the Emblems Act. So 4 points have been given: deceives the public, hurts any religious sentiments, contains scandalous or obscene, or has become prohibited. So there was a case where someone wanted to keep his brand name Mahabharat. So they say that, listen, it has become already, it's a religious sentiments you cannot use. So religious things cannot be used. Simple. Have your own mark. Now when we move forward, 9 subsection 3. So subsection 1 is there, absolute grounds of refusal. Subsection 2 was about don't with the which hurts religious sentiments, okay, or deceive the public, scandalous or prohibited in the Emblems Act. Now we'll see your trademark as a shape. So again, if it is under section 9, it is prohibited. So a mark prohibits the prohibited that if it consists of exclusively of a shape. So for example, if I want to keep a circle as a trademark, so this lacks distinctiveness, it cannot differentiate from others, and it will disallow everyone else. Okay, so it will be disallowed. Consists exclusively of a shape. However, if shapes, 3D shapes have been allowed because they can distinguish. Even when you see the Audi logo, it has 4 circles. So that also has been allowed. Okay, but a pure shape is not allowed. Exclusively one shape is not allowed. Which results from the nature of the goods themselves. Means I draw the car. So this is also not allowed. Okay, it is, you're drawing a shape which is looking like the nature of the goods. It is describing the technical result that you're doing. Like even one example I give, which was allowed actually. Tata Tigor EV. So EV word is written. What does it do? It shows the technical result that it is a EV car, or it shows the substantial value of the car, So $1, so it has the value 1. So a shape is not allowed if it consists exclusively of the shape of the goods, which results from the nature. It's a, you're drawing the car, which you're writing a technical result like EV. Just the word EV is not allowed. What did they do? They registered it because the Tata Tigor EV, then it is allowed. And exclusively shape is not allowed. Only shape is not allowed. With some a mix match you can do. So one alone would not be allowed. $1 store. All of them, they have one exception. If it become well known, it will be registered. So you see Tata Tigor EV. It shows the technical result. Okay. Then so nine we are done. 9 we are done. We did all the subsections also. Now we are looking at relative grounds for refusal. Now when I say relative means what? Means in relation to others. In relation to others. See, earlier what I did, I was keeping obscene marks, I was keeping the mark, I was keeping one single shape. All that is not allowed, is absolute refusal. Now relative refusal means what? It is messing with other brands. So it is conflicting or violating or copying other brands. So you are copying other brand. That is why it's called as relative, and related to others. So here they have said section 11. Section 11. What does it say? Section 11 subsection 1. Now pay attention. They have given you 3 points. That establishes conditions under which a trademark cannot be registered. Why it is coming in subsection 11? Because it is in relation to others. So you are using maybe the mark which is exactly the same, similar, etc. So see, first one is you are using identical marks, okay, and the goods and services are similar. So first point is, I want you to note it down, so I'll make you learn only now. Section 11 subsection 1, okay, subclause A, what does it say? That you're using the, okay, the mark, and we can say the goods or service. So mark is a trademark is identical and the goods and service are similar to another person. Okay, the B part, let's see what the B says, and then we'll see what the C is also saying. Clause B and C. Now what am I doing? I'm using a similar mark but in identical or similar goods and services. So you are using similar mark for identical or similar goods or services. And C, yeah, so that is it. So subsection 1 and 2. So what are we doing? Just note it down. Relative grounds of refusal. So if I am using a trademark which is identical, exact same logo I have used for my goods, which might be goods are similar or in similar category. Okay, so for example, I have used the exact Apple logo for my laptop or my iPad, for my tablet phone. So what is happening is they are saying that it's an identical mark. Maybe the goods are similar, but still it is a relative ground for refusal. So it is a relative grounds for refusal of trademark. Okay. Second, maybe the mark is not exactly the same. In the above I use the exact same mark. For example, there was Starbucks, okay, and there was a person from Punjab. He used something called as Sardar Bucks. Use the exact same color, font, everything. Now there is mark is similar, not exactly the same, and the business might be, the goods and services are dealing might be identical or similar. Then it becomes the absolute ground for refusal. Simple. So just remember, identical goods are similar, but you're using identical marks, should be refused. Now here, if you're using similar marks, which is causing a confusion, so that also can be refused. Now I told you that if, now subsection 2 talks about dissimilar goods and services. Now pay attention. Protection of well-known trademarks in dissimilar goods and services. Now, as an exception, you can always write that if a mark has become well-known, okay, then even if the business is dissimilar, still it can be refused. Sir, means what? So for example, let's say Apple logo is not registered in India, but if I come out with a backpack of Apple logo, so it has become so famous that even if the goods are dissimilar, people will assume a trade connection, that maybe Apple has launched a bags. So that is why well-known trademarks are there. They can be, because you become well-known in the eyes of mind, it will be refused. Simple. Okay. So there was an example of McDonald's and McDowell. So this was a case. Now if you go to see, this was the original and this was the copy. Okay. With the consent of the owner, you can always do. Now what all factors? Now we saw that if a well-known trademark is there, it could be still protected even if unregistered. So you will write a line that a well-known trademark is protected even if it is unregistered. Still it will be protected. Now the question comes up that how will I identify whether a mark is well-known or no? So the following things, you will see the public recognition. You will do surveys, public knowledge and recognition. We will see for how long you were in the business. You will look how much you have spent in advertising your brand. We will look at your registration history, when it was there, which all areas you were there. We will look at the various places where you have become successful as a thing. Let's say if you were successful in one country in protecting your brand, you can give that order copy. Government will say, okay, fine, this person is successful in one territory, so he will be allowed here also protection. Okay, so this you can write about well-known trademarks. Registration process we've done, simple, that it should be completed. You'll get a certification of registration. The entire registration process will be completed within 18 months. Now, this also we have done your duration of registration. In under section 25, it is registered for 10 years and after that renewal is given for successive 10 years. So this you can remember, renewal process timings also. From this chapter I have told you section 9, 11, 29, 30 and balance part is the basic concept which you can build. Now very important. Sir, we come to section 29, 30. What is section 29, 30? So section 29 is saying very important, infringement of trademark. What does infringement mean? Can anyone tell me what does infringement mean? How, if someone will tell you what does infringement mean? What does infringement mean? Define. So infringement means unauthorized use of a registered trademark. Clear? See, you can note it down and note this also, that a unauthorized use of registered trademark and unregistered trademark. Okay. Now, if it is a registered trademark and someone has used it, applied it on their goods and services, have applied some, deceptively similar goods, which is causing confusion in the minds of people, where they are associating trade connections with the goods. So, if you are trying to create a kind of a confusion, then it is called as unauthorized use. If a registered trademark has been misused, then case will be filed and it will be called as infringement of trademark. When unauthorized use is there of unregistered trademark, then the same application will be called as passing off. Same thing will be called as passing off. Now, normally unregistered trademarks are never given protection. They will say, why didn't you get registered? Only one exception is there, which is called as in well-known trademarks only protection has been given. So only if you have become so well known that people are now associating trade connections, if that mark is put on any other, they are associating that it is your goods. Only in such cases where you have to prove that you have become well known by showing the advertisement, your registration history, the amount you have put in ads, the public recognition and memory. So surveys will have to be done. Then only you will be protected. Now we see section number 29. This is given under section 29. And 30 says what is not registered, what is not infringement, what is allowed. Okay. So now we start. Infringement of trademark. Okay, I want you to note it down that infringement of trademark. So when a registered trademark is used by a person who is not authorized to use, it's called as infringement. Okay, the section 29 talks about infringement. Section 30 talks about which is not infringement. So section 29 says infringement of trademark. Section 30 says what is not infringement, means permissible use is covered. So both are important. So these are all permissible use is permitted. Okay. Now there was a very classic case, okay, where of the trademark of ICAI was there, of the trademark ICAI. Now chartered accountants was using their trademarks from many years, ICAI. Now even the Institute of Cost Accountants of India, so if you see, they also applied the ICAI logo. So the Chartered Accountant Institute filed a case on the Cost Accountant Institute, and they said that if we both will use the same marks, then it will cause a confusion in the minds of people. And then the court, the Delhi court, they ordered the Cost Accountant Institute to not use ICAI, okay, as their thing, because people will think about chartered accountants, and now they use the word ICWA. Clear? This is there. Now section 29, okay, section 29 subsection 1 subsection 2, 29 subsection 1 subsection 2, then we see subsection 3 and subsection 4, subsection 5. Okay, so let's see from here what is important we will do. So first thing is section 29, you can directly start writing that infringement occurs when a person not authorized uses the trademark, whether they are using it exactly the same or they are using a deceptively similar mark. Deceptively similar means what we saw, McDonald and McDowell, Starbucks and Sardar Bucks, that is deceptively similar. How do you define deceptively similar? Means it causes a confusion in the minds of people. Okay, it causes a likelihood of confusion. So how will it be likelihood of confusion? So if we are using the mark for similar goods and services, or we are using similar, remember we had done for relative ground, similar points you can write. Similarity of trademark and similarity or identical goods and services, same points, identical, is likely to cause a confusion in the minds of people. So for that section 11 we had written, right, identical, similar. So same point they are saying that you are using same identical mark for similar goods and services, you are using similar mark for identical. So one side they tell you mark and the other side they tell you industry. So what happens if it falls under section 29? Okay, if I'm using a identical or deceptively similar mark. Sir, what does deceptively similar? Deceptively means it deceives the people, it causes a confusion in the minds of people. If it is there, then the court will presume that if all these cases are there, then court will presume. So if section 29 2C 29 2C is there, identical marks is there, an identical mark and identical goods and services, then the court will presume that there is confusion. So you are using same product, same mark, similar product, or similar mark, same product. So all this is there where it is very, some connection is there. So that time the court will presume that there is a likelihood of confusion. Okay, same points you can write. It, what does it do? It gives, why would someone purposely do this? Because it gives a either a unfair advantage to someone, or it harms the reputation of the other brand. Okay. Now one more point they have given you, 29 subsection 5. Now pay attention. That infringement also occurs when the trademark is used as a part of their own trademark. When one person uses a trademark, your trademark, in their own name. So an example of this will make you clear that if the company XYZ Limited is registered and is already registered. So we have XYZ Electronics already registered. Now someone else comes to register XZ Electronics, Raj XZ Electronics. So law will say that, listen, XYZ Electronics is already registered. You have taken XZ Electronics, you are registering. So what you have done, there are some part you put it in your name. So infringement occurs when you have used a registered trademark. So this is a registered trademark. This has been used out here as a part of your trade name. So that is also called as infringement. Simple. So there are different kinds of infringement that you are doing. So you'll write that and done. Okay. So acts constituting. So what the person must have done. So with that mark, he must have put on his goods and services. He must have displayed it. He must have done import export with that goods, or he must have used it on other business or advertising purpose. So all these are infringement. Then comes to the next one is section number 30. Section 30, I told you section 911 is important, and section 2930. 29 talks about all those cases of infringement, which is simple because anyone using your brand is an infringement. You'll go open section 29 and file a case. In 30 it says that, listen, these are not infringement. So they have given you cases which are not infringement. For example, if multiple cases they have given you, you have to remember few of them. What does not constitute infringement? For example, honest practice. So if I'm normally dealing, I'm doing something, I'm not taking any unfair advantage, then it is not and not detrimental to the brand, or no unfair advantage is taken, is not there. They've given you a few examples. A trademark is not considered infringement where it is used to describe the characteristics. Okay. So example, if I take, it does not constitute a. So for example, I am using if a trademark is used to describe the certain characteristics of their goods and services. Okay. So for example, I am doing a product reveal, or I am doing a unboxing video. So to explain their characteristics, their usage, so in the bona fide use I'm doing, it is not there. Not a thing. Okay. I adhere to the owner has given me permission, or owner is allowed to use the trademark, then again it is not a violation. Then proprietor and proprietor user, as I told you, if he is using it, is not a problem. Then trademark on accessories. So some points you can remember from your note down. For example, a Apple phone is there. Now I'm manufacturing an Apple cover, so I can use it. Why? Because it's an accessories, and I have to use it to sell that particular accessory. I have to use the which brand it belongs to. So a trademark can be used as an accessory. You can use someone's trademark as an accessory if it is reasonably shown that why it has been made to make it compatible with that goods. Coexistence of similar trademarks can be there. Similarity is allowed. Okay, as long as it is not creating confusion. Okay, lawful acquisition of goods is not an infringement. Now pay attention to this. If I've got an assignment we saw from another person, so assignment is I through a written agreement I got, it is not an infringement. So all the cases they've given you. Now one more point is there. Let's see where it is. Let me complete it. So let's say if I have bought your Apple phone. Okay. After buying the Apple phone, and now I can I'm permitted to use it, right? I'm permitted to use the Apple logo. I will obviously not for commercial purpose, but I can use it to put on my Instagram. I can even use it for resale. So consumers using it can obviously deal with the brand because they have paid the money for it. Okay, so that is what it has been given. Okay, so anyone who has bought the goods once it is sold in the market, okay, then further sale of that is allowed. It is not an infringement. So this is a doctrine of first sale. So the doctrine of first sale or exhaustion doctrine. Now what does it mean? That trademark protection is only there till the first sale. After that, then everybody can deal. For example, I buy an Apple phone, then I can sell. Nobody can stop me from reselling because I've already purchased it. So once the goods bearing a trademark have been lawfully acquired by a person, so a consumer has purchased it, then the trademark rights is exhausted. Now nobody can stop me from displaying. Now I take a selfie with the Apple thing, it is not allowed, and the person can even sell. I want to sell it on OLX. So Apple cannot say why you are selling my phone on OLX. So I can sell and deal without infringing the owner's rights. So the owner of the brand will have rights over the product only till the first sale. This is called as the first sale doctrine or the exhaustion doctrine. On the sale where someone has lawfully acquired it, all the rights is seized. Now the owner will deal with the product as he wants. Okay. Now, as we have done this, that authorized, unauthorized use of a trademark, registered trademark is called as passing off, unauthorized trademark or use of a trademark is called as unregistered trademark is a passing off. Okay. Then I've done passing off same points. Now passing off is when you file for unauthorized use of a mark. Okay. Now passing off, there was a case of Honda versus Sarabjit Singh. Now what did he do? He took the Honda logo and he was putting on pressure cooker. So then the Honda company filed a case that listen, though we are not registered in India, but you cannot use it since we have become well known. That logo people are associating a trade connection with me. So then they said it is not allowed and it is an actionable tort, means compensation will be ordered. Okay. Now if there is any relief, what relief you can claim for passing off an infringement? Injunction, damages, delivery of all the goods which are there, seizure, confiscation, arrest or fine or penalty. So you can note it down always, you can quote it also. Okay. And once registration is done, it is a prima facie, it is a prima facie evidence that the owner is the correct proprietor of the product. Now again, one small little point is if a person trademark removal of trademark for non-use. So if a person has not used the trademark from registration for 5 years, so a trademark is not used within 5 years from registration, it can be removed by the person. Okay. And he can apply for restoration if it is, if it was a genuine reasons are there, he'll have to satisfy. Okay. Then comes trademark agent. Very, very important. They can ask in the exam who is a trademark agent. Do you know that on clearing your company secretary exam, you automatically become a trademark agent. Now see, qualification of a trademark agent, that the Trademark Act. Why do we have trademark in so much depth? Because automatically on clearing the exam we become trademark agent. So trademark person agent. So a person can be qualified to be a trademark agent if he is a citizen of India, not less than 21 years, or is a graduate of a university. He has cleared one examination, or is an advocate or a member of ICSI. So the scope has increased tremendously. That if we are a citizen of India, we are not less than 21 years of age, and we are a member of ICSI, so we are deemed to be a trademark agent. So beautiful scope for CS. Okay, and you can apply for becoming a trademark in form TMG. Okay, TMG you will apply for this. With this we have completed the entire chapter, including the important topics from this chapter. Thank you. Clear? Till here it is clear, yes or no? Just write clear in the chat box. Till here it is clear, yes or no? Write clear in the chat box so we can move ahead. Okay. Now we'll go and complete the other topic. We'll go and complete the other topic also. Okay. So we'll take a 6:30. We'll be back, and we complete your Designs Act also. Okay. Till then, you can revise any particular chapter that you have, part A or something. We'll be back and complete this particular chapter. Hi guys, am I audible and visible to you all? Just write AV in the chat box so I can quickly start. Quickly AV in the chat box, everyone, please. So help me start really quick. Okay, everyone, if nobody is mentioning, you mention. Okay, everyone, whoever can hear me, put in the chat box AV. Forget about it, don't wait for others to put. You put it, let me move ahead. Okay, I can quickly start. So AV is audible and visible. Okay. Registration. Okay, great. Let's start. Hi. So we start with our topic, which is called as Designs Act 2000. Now, before we start, we can quickly just go through the exam questions, okay, which have been asked in the past exam. So one they have asked with respect to section 4, okay, design means a design which has been registered and not been published anywhere else. Definition clear. Then they asked what is the duty of the court while determining if the design is new or original. Okay. Then they said what is the duration of the design and can it be extended and how it can be extended or registration or cancelled. Okay, and then you have your sections 19. Okay, that a design may be cancelled on the following grounds. Done. Okay, so let's get into it. Hi, so we start with our Designs Act 2000. Now, designs comes under the office of the Controller of Patents, Designs and Trademarks. So there is a common controller. There is a common controller. Okay, normally they say Controller of Patents, Trademarks, Designs. They all three are under the same head. Now, can anyone tell me why? Why does all of them come under the same head? Because all of them are capable of industrial use. So anything whichever is of industrial use, they all come together. So a trademark is printed, manufactured, a design of a bottle, of a car, of a architectural designs of your mobile phone. So those are all industrial use. Even your patents are for inventions. So all these three comes together under the Ministry of Commerce and the Department of Promotion of Industry and Trade. Okay, so this hierarchy we can write it in all the cases. Now let's understand is what is a design. First simple little thing. Now if you go to see very common, we look at jewelry. Now everything might be 24 karat, but still you will choose something which looks beautiful. From these two, can you tell me which is more better, which you would pay more money for? Considering both of them have the same amount of jewelry inside or the same value is there, you would obviously choose the second one. At least I would choose the second one because it looks more beautiful. Now beautiful is this goes in industrial designs where it would be manufactured, etc., and then sold individually to the consumers. So what is a design we will see, but then we also see designs of cars. So you would be able to recognize which car it is there, especially if I just don't show you the logo, you would easily be able to say it's a Lamborghini if you know about cars. If I show you this car without even showing you the logo, you will be able to say it is a Bentley. Okay, if I show you this car without even looking at the logo, just from the car design, you would be able to say it is a Maserati. So designs, what are exactly designs? So designs is any shape. Design, we'll see the definition, is any shape or any pattern which is appealing to the eye and capable of industrial use. So what do you mean by design? So design, as we saw all those designs, nowadays even clothes designers are there, their designs are getting copied. So they register themselves in design, but never you will see the word designs written. They write the word industrial designs. Okay, and industrial designs are administered by the Designs Act 2000, and the rules are of 2002. So this we will write in the exam. The object of the design. Sir, what is the object of the design? Again, we will write this in the exam, and I will also tell you some case law which you have to write. So I want a book pen, you should keep noting it down. Now, why should we grant protection to designs? Imagine if I am a designer, I am a jewelry designer, I am a Manish Malhotra. What does he do? Manish Malhotra, there's one more guy. What does he do? Manish Malhotra, he is known to make very beautiful garments. Now those garments are, the design is the main element, okay, how it looks, etc. So then they get registered. Design gives them a copyright in the designs. So the language that they say is that you get a copyright in the design. Means they have a right to make copies, they have a right to sell the design, and they have a right to prohibit anyone from copying the design. So this encourages creative people to design better. Okay. So the entire logic of your IPR, intellectual property right, is to give the creators, two rights: positive right and a negative right. Positive is the right to use and transfer, and negative right is a right to prevent others from using. If someone is using my design, then I will file a case of, how do we have infringement? We word the word, but here we use the word piracy. The language, okay, you will use is piracy of designs. Piracy of designs. Piracy of design means unauthorized use, which is infringement. Okay, but this is the language. Copyright in the designs and piracy. If someone copies your designs, you will say that it is a piracy of my design. If they've used the thing or they have tried to sell your design, etc. So design encourages, this Designs Act gives protection to the people, and because of which you get a encouragement. Okay, it gives them monetary, you can gain due to the designs, give them protections, protect from the IPR, and monetarily reward the innovator, where he will be able to sell and explore, or we could say exploit his designs. Okay, this is a bit of history. How did it come? Now, even if you see, designs are also there in shapes. Design is also there in the shapes. Okay, so anything, design is any shape where it any pattern which is appealing to the eye. So if you go to see, even if I remove this, you will be able to see the bottle. I just look at this bottle, the color, etc., and I can get it under the Designs Act. Okay, I can get registered under the Designs Act. Now copyright will come, so that's why they just call it as a copyright in designs. That is how it is used normally, which even if I have a graphic design, that will not come here, because we want something which is capable of being industrial application, manufacturing, etc. Okay, let's see. This I want you all to note down and write in the exam. Okay, no matter what question comes in the exam, you will write the introduction, the object. So whatever question comes in the exam, I want you to write the introduction to the act. I want you to write the introduction to the act. I want you to write the object of the act. Object of the act. In the object of the act, you will write this case law mandatorily. It tells you what is the primary aim or the object of the act. So it can easily be filled everywhere. So just remember the case law. Escort constructions versus Action Construction Private Limited. Escort versus Action Construction Private Limited. It says in this case they have told what is the object of the design. So the object of the Designs Act we will write, and we see that we are not talking about the function, we are talking about the look. So here it is not the function, it is the look. For example, in the car, I am not telling how the car is operating, that is not covered under Designs Act. In Design Act, the shape is covered. The shape is covered and not the actual function. Okay, that is covered. Now, again, one more thing I want you all to write, as I told you, this case law we will definitely write in the start, and also we'll write the definition under section 2D. So design means what? So as I was telling again and again, it's a shape, but also you can say it is a shape, configuration, pattern, composition of lines, colors, etc. applied to any article. Okay, so this is for any article only, for any goods. Okay, so first thing is design means a feature of shapes, configuration, pattern, lines, colors applied to any article. So just think of a car, of a dress, or maybe architectural designs, jewelry designing. Okay, all of them they will come here. So design means any shape applied to an article. So at least this much English I need from you all. Any shape applied to any article, one. Okay, which is 2-dimensional or 3-dimensional. And I told you it will be of industrial usage, means manufacturing ability will be there. Okay, and it is appealing to the eye. It is appealing to the eye. It is beautiful in looking and does not include. So this all does not include a mere function, or the mere device itself is not included. We are talking of the shape of the design, and it doesn't even include the trademark. So which brings me to what is the difference between a trademark and a design. A design is of a bottle. You look at the design is a shape, whereas the trademark is the particular name of the brand, etc. Trademark is applied on all articles, right? So whether, let's say, Apple, I'll give you an example. When I'm talking of Apple logo, okay, Apple logo will be put as a trademark. Okay, and let's say this trademark is put on everything: laptop, phone, earphones, iPod, your notebook, everything. This logo will be put. And let's say they design a particular laptop, and the shape of that laptop will be copyrighted in the Designs Act. Shape. Okay, so shape is product specific. It is product specific. Okay, so it is that pattern of the shape which will be protected. Okay, so the shape is here, and on this the logo will be put. Okay, so shape could be on 100 things, the logo could be there on 100 articles, but the design is specific to that product. Sir, understood. For another example, if I give you, as we saw TBZ, Tribhuvan Das, this jewelry maker, so they have a brand logo, they will put it. But when I speak of a specific necklace, that design will come here. Okay, sorted. Sir, beautifully understood. Let's understand. Now, this is the logo. Rolex is the logo, and this logo is applied here. But when I'm talking about the shape of the watch, the shape, the color, the patterns is covered under the Designs Act. Understood. So what do you mean by article? See, can a design be there of services? Yes or no? Can a design be there of services? Answer is no. It's very clearly mentioned that it is an article capable of being manufactured. Okay, is covered. Done. Now, the language that we will speak, that once it is registered, we will say that the person, the designer, will have a copyright in the design. What we will say, we have a copyright in the design, and it gives you two works. You can positive right and negative right. Simple. Okay, so design and trademark, I've told you, design is about the physical appearance, okay, and design of an article, whereas a trademark is applied on multiple things and it is the brand of the company itself. Now, when we come to the proprietor of new or original designs, obviously, who is the proprietor? Now, pay attention. In 2J, we are trying to understand who is the proprietor of any design. Proprietor of any design. It is given in your section 2J. So, who is the proprietor? Understand. One very simple. If Manish Malhotra has stitched a dress, he is the proprietor. But let's say normally, if, for example, Manish Malhotra himself doesn't do, sometimes he might have a tailor. So who is the owner of the design? He's tailor or Manish Malhotra? Employee or the principal? So obviously they are saying that the employee has worked for the principal, so the principal will be the owner. See, the author of the design or the owner of the design will be the one where the work is executed by some other person, then it will be the owner, the person for whom the design is so executed. So for the person for whom the design is so executed is the owner. So employee is not the owner, the principal is the owner. Or second is someone who has acquired by paying money. Imagine if you had made a design and I pay for it, then I become the proprietor of the design. The person by whom the design is so acquired, the person by whom the design right is so acquired is the can be called as a proprietor of the brand. In any other case, and normally if all these cases are not there, then it will be the author of the design. Anyone who made the design is the owner. Now, prohibition. Now this is common in almost all the intellectual property rights. So once you do IPR of one thing, you will realize that IPR of everything has the same language. Now we are doing section number 4. So if we see the Designs Act, first is we are starting with registration. So we start with prohibition. Okay, what are we doing? Prohibition of registration of certain designs. So in the exam they can ask you which designs cannot be done. Which design, and it's very common. Let's say any design which is already known, any design which is not new, any design which is against public policy. So those will not be allowed. So which is not new, which is published already, okay, it is obscene, or it is not distinguishable the known design. The design is very vague, it is not very significant, it is not very great design, so it will be rejected. If it doesn't have any special characteristics, it can be rejected. So 4 points, 1, 2, 3, 4. So if it is not new, already known design, it is obscene, or it is not significantly different. Okay, then we come to section number 5. Now section 5 is about application for registration of design. So we did 4. Now we're doing application for registration of design. Very, very simple. As we saw, there is a common controller for industrial technology, like common controller for trademark, patents, designs. So you make an application to them through then you have to make the fees. The controller will normally publish the designs, ask for objection. This is the common process for registration of any process. Okay, so if you understand one intellectual property right registration process, all you will be able to build. So registration will be for any IPR, whether it be trademark, copyright, patents, anything. So very first thing what happens, you make an application. Okay, before application you just do a research. So before application you do a search whether it is available or not. So you will do a search, a public search whether that design is owned by someone else or no, that you will do. Then you will make an application. Application is made to controller. The controller, after he can appoint an examiner. He will put a examiner to see whether the design is proper, owned by anyone else, etc. Then it will be published in the journals. It will be published in the journals for objections. If anyone is there, they will make a objection that they are opposing to the particular any intellectual property right. This I'm not teaching you only for designs. For anything, trademark, copyright, patents is the same format. Okay. 6. Then objection will be heard. Okay, and in the end the final decision will be given and registration of the intellectual property rights will be done. Clear? Objections, controller, application, etc. Now in registration is also there, and when it is not allowed. So not allowed is when any now this is also common answer, it is for IPR. If it is already publicly known, it is not new, okay, it is no inventive step means it is nothing new, okay, it is not bringing any advancement, no change, no distinctiveness, then it will be rejected. It is against public policy, so all these cases it will be rejected. Same points will be given here and you can close. Okay, it is not new. Okay, the controller will first look whether you are saying it is a new designs, not publicly published, and it is not contrary to public order. So controller will study your application and he'll see that whether all these conditions are fulfilled, then he'll tell you to fill in the form. He will tell you under which category that design will come, clothes, textile, cars, it will there, and then it will be allowed or disallowed, and on this you will get a protection. Simple. Now when you apply, let's say application date is here, okay, and the grant date is here, I want all of you all to think and tell me that protection will be given from which date? From the application date or from the grant date? You will be protected from the granting date or the date of application. Quickly, because this is again common for all the intellectual properties. Okay, this I am not teaching you one chapter, I am teaching you all the chapters. Quickly. Okay, so it will be your date of application. Always remember that the design, any intellectual property right, the registration might come later, but you get protection from the date of application. So the design shall be registered as on the date of application. So in between also, if someone has done, you can always file a case on them. Okay, so you are protected. Now key questions, requirements for design. It is not only for design, it is for all the intellectual property. It should be new, novelty, originality should be there. Okay, it since except for copyright, everything else should be capable of industrial application. Now when we see of design specific, it should be an article, ornament, shape, etc. on an article, goods only. It should be appealing to the eye. It is not covering the process of manufacturing process, functional process is not covered. How the car is running, we are not concerned. How the dress, how cool it is, that is not covered. Okay, what is covered is the design aspect. Okay. Now, registration of the particular article. So, it will be registered, decision will be final. Okay, it will be rejected if it is not new or it is priorly published. We've done this. Now this also is a very common point. Understand, it is there for everything. Ownership change during the application. So there could be a merger and amalgamation. There could be a death and there is a legal representative. Yes or no? Or there could be a court order. In that case, the ownership has changed. From company A it went to company AB, or from the father it went to the son, or company A said no, not company A, company B. So in that case, thus the application owner will be substituted into the new owner's name. So now we'll take instant, let's say I'll give you a simple example. Now this is common for all the intellectual properties. That let's say if there is company A and company B. Now let's say company A and company B, they got merged into company AB. Now this company had a application pending. They had a application pending before the controller, and during that time they got merged. So now what will happen is the ownership has changed before the granting. So company AB will now apply that to the controller that listen, the ownership has changed during the application, please grant me. So then the if it is not a court dispute, then court will say that give a consent letter of the original applicant. That's it. So it allows the design to continue even if the applicants, the owners have changed. Okay, it allows where a person has made an application for registration, okay, for an article, and that design has been previously registered by another person, or there is a modification, then at any time when the application is pending, the applicant becomes the registered proprietor. So now any person in between becomes a registered proprietor, then he will be continued and the act will apply accordingly, means it is allowed. Okay, he will be treated. So the new guy will come in, apply, and then we will continue from there. Okay, now once a design is there, in order to get registered, the controller shall after the registration of the design cause a publication, okay, and this will be open for public inspection. So they are saying after it is also there, a register will be maintained of which all designs has been granted. Even for buildings etc, which is there, architectural designs are also covered. Now substitution, this concept are covered in section 8, that the owner has been substituted, so it is covered. That is also covered, same points as I have said. Now certificate of registration. So section number 9 says that the controller will grant a certificate of registration. Now what will be the effect of the registration certificate? You will have a copyright in the design. What is the language? You will have a copyright in the designs. That means you have an exclusive right to copy the design, use the design, and also positive. This is a positive right. You also have a negative right to prevent others from using the design. Simple. Now for how long? Very, very important past exam questions. Okay. So it will be for 10 years and one renewal is allowed for 5 years. So total 15 years only. After that it is not allowed to be renewed. It will go into public domain and it can be reused by anyone. Means what? Let's read. Section number 11. See, we come here. Now you've seen one important thing, that copyright of the registration. It is there for how much time period? So initial copyright period will have a copyright. So where a design is registered, it will have a copyright in the design during 10 years from the date of registration. Okay. Now extension, here they've given date of registration. After the expiration of 10 years, it can be extended for a second period of 5 years from the expiration of the original 10 years. So after 10 years, so total 15 years only, 10 years initial period and plus 5 years it is there, and after that it will no longer be protected under Designs Act. So 10 years initially and 5 years more on renewal, design will be there. After that protection is not granted. Okay. Now imagine how much time period you had. Total 15 years. Let's say I had registered a design. 3 years after this I have to pay renewal. I have to pay some fees. Okay. I did not register. I did not do the renewal. 5 years I did not do. Later I realized that so if now this line also you can write. Okay. That if there is registration of your now this is common for all the particular intellectual property right, trademark, copyright, patents. Registration of IPR is there, so you will be protected under law. Now let's say if renewal not done, so if you have not done the renewal, okay, if you have not done the renewal, then in such case, if renewal is not done, then you will not be protected. Common sense, na? If I have not renewed it, why will law protect me? Okay, law will say you did not pay us fees, now someone will use it. So during this time, if anyone has used that design, has used your intellectual property, I cannot file a case, because if it has lapsed, okay, if it has lapsed, then it protection will not be given by law because you didn't pay the renewal fees. Now imagine if you want to restore lapsed IPR, intellectual property rights, you want to restore it. So obviously you will pay the money, but the time that during which you are not paid, you will not be protected. So restoration application can also be made. Simple is what is the point. Let's read it. So within 1 year, when it ceases to exist, so let's say you did not pay for the charges, so it will lapse. Within 1 year, when it ceases, you have to make an application for getting this second life. Okay. So where the proprietor of a design has fails to pay the necessary fees, he will lose the protection in the IPR. Common sense, if you not paid to the government, law will not protect you. Now when he realizes his mistake, the proprietor or the legal representative may apply for restoration of the design within 1 year from the date of having effect. Okay, and then they will get the protection. Simple. Now again, very important, a past exam question also they have asked. Now this is also same. This is also same as all other intellectual properties. That when can the controller of design cancel your registration certificate? So obviously it's something where you will be sad. So these are the same grounds where registration is refused, same grounds will be given. For example, it has already been previously published, the design is not registrable, it is of someone else, a court order has come. So same points it will be there in section number 19. So we read your section 19, cancellation of registration. So when it is done that the design has been previously registered in India. So we had made a mistake, we gave you registration and then we realized that there was a similar design registered, so we can cancel it. It was already published in India or somewhere else prior to registration, so it was not new, it was something already publicly known. The design is not new or original, it is not registrable, and it is not a design only. In all these cases it can be cancelled. Okay, designs to bind the government means what? Can the government use your design? Answer is no. Simple, that even the government, from the date of registration, even the government has to bound by the rights and the protection of the design. Means even the government has to protect your designs. Now as we see that if there is a unauthorized use, normally we always call infringement. Here it will be called as a piracy. Okay, so just the language is different, concept is same. So what is the meaning? So you will say unauthorized use of a registered design, okay, is called as piracy. Okay, so how piracy can be done? So piracy obviously is not lawful. Okay, and you can ask for compensation and all those remedies that we had done, they can ask. So when can someone do piracy? When it can be said that someone has done piracy without the consent. So if they have applied that design to their article, someone has used the same shape, and if you go to see now, there was one Tata Mahindra, they have used a Lamborghini car exact, it is so similar, the design. So Tata Mahindra, if you see one of the cars, very similar to Lamborghini. So if they have done, they've kept it similar, so maybe it could be said that it is unauthorized use. Someone has used that design on their product. If someone has imported the design for sale, so import such article for the purpose of sale. So even if you have imported an article which has your design, you can file a case. And last is if any design has been published or it has been published for sale. So someone is coming and saying that this designer dress you can do or you can use, you are selling the designs. Okay, the design, you make a particular catalog that these designs are there, you can take the ideas and go. So this is also called as piracy. So what is happening? You have either applied it to an article, you have either imported that design, or you are publishing that design for sale. So all this is called as piracy, and all this is happening. What piracy of a design means, that the design is being, all those things that is being done, okay, without the consent of the registered owner, proprietor or owner. Okay. Now even one small little titsy bitsy point they've given, that imagine if a design, now we have these international exhibitions, etc. Imagine there is a Dubai Expo, you've gone there and you've showcased your design. So it will be said that you have already published that design. So still you will get protection provided you have the condition. Okay. So what is the condition? That before going to that expo fair, etc. So imagine if a business owner is there, he has made a design. Now he goes to an exhibition, international exhibition, etc. to showcase his design. So it will be treated as publicly known. So before going to the exhibition, he already gives a notice to the controller about the design. Then he publishes it in the exhibition, and within 6 months from the date of the exhibition, he is applying, so it will be registered in his name. See what they've said, that the Design Act says that regarding the exhibition of a design at an industrial and international exhibition. So someone has exhibited this design. It is stated that the exhibiting a design in government approved exhibition doesn't create a barrier from registration of design, provided condition is there. The person makes an application within 6 months from the conclusion of the exhibition. So moment the exhibition gets over, within 6 months I have made application for registration of the design, and this should be done by the owner only. So first is, two conditions are there. He has to give a prior notice to the controller that he is going, and the registration application should be made within 6 months. Okay, appeal. So if you are unhappy with the decision of the controller, appeal lies to High Court. Okay, and every appeal shall be made within 3 months from the date of the order of the controller. Okay. Now instead of High Court, we also have the Intellectual Property Appellate Tribunal. Okay, so appeals are made to High Court from any of this refusal, cancellation, or any of the refusal on grounds of morality. Any of the refusals have been done by the controller, you can go to the High Court. The powers given to the Intellectual Property Appellate Tribunal. The appeal should be made within 3 months, and that is it. We have completed the entire chapter. Thank you. Clear till here? Yes or no? Write in the chat box clear, so I can quickly go to the next chapter and complete it. Sir, questions. What are you saying about questions? Okay, I'm showing also which all questions are coming in the exam. Okay, now I just want to come up one more small little titsy bitsy chapter, that is Geographical Designs. Geographical Indication Act. Okay. Then after that I'll take a heavy chapter, which is your Patents Act is the most technical. If you do all the other chapters, then Patent Act will become simple. Okay, if you directly take Patent Act, you will get a heart attack. But when you do all the others, it becomes easy, and then do this chapter. Okay, we'll do one more. Then you'll see a similarity between all of them. You will see a similarity between all of them. If you're studying, also study in the sequence that I'm showing you. Your life will become simple. You're finding it simple, right? Because we are going in a certain sequence. Patent Act is a little technical, but when you do all this, you already have an idea about how the intellectual property thing works. Then you'll find it easy. Okay. Now we'll do Geographical Indications Act. Okay, so penalty provision not that important. You can just learn few general ones if you want. Okay, I don't think they will ask you penalty provisions. If you want 1-2, you can learn from your end, and just in case anything comes, you can quote that. Or you can write general provisions. You can write that imprisonment, fine, confiscation, restoration, injunction. Those common points you can write and close. Okay. Now we start with the Geographical Indication Act. We'll take a 10-minute break. We come back at what time is it? 7:45. Okay, 10-15 minutes. Till that, you revise your job. So, though I'm taking a break, but you will revise one of the chapters of part A and complete it during this time. Okay, so your job is to finish some chapter of part A before you come here. Okay, so simultaneously with my part B, your part A will also get over. So pick up one chapter that you can complete in 15-20 minutes and come back to complete your part B. Hi guys, am I audible and visible? Please put in the chat box so I can quickly start. Just put audible, visible in the chat box so I can quickly start. We'll be starting with a law relating to geographical indications. Okay, just write audible, visible in the chat box so I can quickly start. Okay, great. Thank you. Let's start. Hi. So we'll be starting with a chapter called a Geographical Indication Act. Now, just before we start, let's look into the law, the questions that have come with respect to the Geographical Indications Act. Okay. So we get an idea that while studying the chapter, which sections we need to focus and what kind of questions do they ask in the exam. So we see one, they have asked what is meant by act of unfair competition under the Geographical Indications Act. Okay, the following is deemed act to be unfair competition. One. Second, they have asked section number 9, which is about registrations. Okay, where registration of GI. Then third, they have asked is with respect to how is a GI different from a trademark. Okay, and then they have asked section number 39. Okay, what is the punishment for applying for false GI? Okay, it's also simple, and that's it. Chalo. Now we start. So now we begin with the Geographical Indication Act. Now the act is covered under your GI Act of Goods Registration and Protection Act 1999, and the rules are of 2002. So remember one thing, that GI indications can only be available for goods, okay, not services. And the rules are in 1999, the act is of 1999 and the rules are of 2002. Okay. Now, before we start, when we look at what is a GI mark and what is a geographical indications. So geographical indication is a mark given to the producers of that region because that region for many years has maintained quality, quantity, purity or a certain standard, and which people start recognizing that if it is from this area, the goods will be much better. Okay, so what happens is when you look at Mahabaleshwar, so Mahabaleshwar is a location in Maharashtra. Mahabaleshwar strawberries. So you will think that we know that goods coming from Mahabaleshwar strawberries will be very, very good. So what happens is the geographical location, with the help of the geographical location, if the goods are originating from that geographical location, we know that the goods will be of a certain quality. Then another, if I see Ratnagiri mangoes. So Ratnagiri mangoes, we know that goods originating from this geographical location will be of a certain standard, quality, purity, and that is why what law has done to the producers of that region, we have allowed them that you can have your own mark and you can tell that these goods originate from your territory. This mark you can put, the GI registry will give you that mark, and only producers of that region can be using it. Okay. Then another, if you go to see, this is Kashmiri, the Kashmiri shawls, they also are there. Then from Andhra Pradesh we have Tirupati laddus. So what happens exactly? Understand that the producers of a geographical territory for many years, like another, if I go to see is this Kashmiri apples, okay, or the Nagpur oranges. So when they are coming from that region, we know that it is of a certain quality. So the producers of that region, they say that listen, if the goods are coming from this territory, it will be really good, and everybody knows that. So then they apply to the GI registry of India. of India. Okay, they make an application. Now the application is not made by one person. Okay, like how this is different from trademark. In trademark, only one person, the owner, will apply. Here, the producers of that region will apply, saying that please, we are giving this application. They will tell on the map where are they located and why the goods are being very distinguished if they come from their territory, and from other territory how are they superior. They will give the application, they will give the description of the goods, they will tell their territory on the map will be explained, and they will create a mark. GI mark also will be given. So special mark they will be allowed, so that we will come to know that it is from that region. The registry, again, just like any other IPR, once the application is received, they will examine that mark. If that mark is genuine, that it is this mark, first of all, should come from a region from which the goods are of a certain quality, standard, purity. Then the mark will be registered. Now before registering, a opposition will be taken. For the opposition, it will be published in the GI journal. Okay, in the journal it will be published. They will listen to any objection, just like any other registration process. The objections will be heard, and then the license will be granted. Simple. Okay. Another Banarsi Pan is another example. Okay, or Kerala tops the GI. So they have multiple GI products coming from their region. Okay. So when we look at the meaning, okay, so first this I want all of you all to write in the exam. Okay, any act comes, first you learn the, so as you see in part B, whenever you're writing any chapter, for every single chapter I want you to write the year in the beginning, and then I want you to write the object of the act. Any answer at least in comes, you will have to write the object of the act at least once in your paper for that fact. So you'll write what is the object, why are we protecting the producers. Okay, so we are protecting the interest of producers so that they can exclude any unauthorized use of their geographical location. So if I know that Kashmiri Kashmiri shawls are very famous, so I will make a shawl and I will sell that this is Kashmiri shawl, because I know that people have started recognizing that goods originating from the territory have a good standard. So then this mark will be given only to the people who are coming from that territory. All the producers from that territory can use, and if anyone else is using, they can prohibit them. Okay, and obviously the another benefit is to promote exports. Once a GI mark has come, in Dubai you see they say we want only basmati rice. We want only Ratnagiri mangoes. So once a GI mark is there, any person from any country will say, oh, GI mark is there, means the goods are originating from that territory. It's going to be really special. I would want to try. Even when I am there, if I have a craving, etc. of food, I say let me order something which is very famous, a GI mark product I will take. And then I had ordered some barfi which was of a certain territory, because I know that that territory is very, very famous. So that way, it can be ordered. What is the benefit? So you'll write the object of the act for all of them. You have 5 acts that you have to learn. All the 5 acts you will write the object of the act. The benefit is to give legal protection to the producers of that area. They will be able to prevent unauthorized use of their geographical location. It will boost the export and create economic prosperity. Now, the definition, or since we know that we are doing the GI Act, we should know the definition of GI also. It is given under section 2E. What does it say? It's an indication. What indication? That the goods are originating from a certain part of a country. Okay, and when they are originating from that place, it has a certain quality, purity, characteristics which is attributable to that region, and no other region it is there. So Tirupati laddus, so we know that it's very, very world famous. That area has become, for so many years they have maintained this quality, and you would want to try. So it not only boosts the economy of that region, but even exports it boost. Okay. So what is a GI indication? A GI indication is that is that the goods originate from the territory and they are used to identify agricultural goods, it could be natural or manufactured goods are also allowed. Okay, provided that the quality and reputation is associated with not a single manufacturer. Quality and reputation is associated with a region, geographical region. So all the producers who for so many years who maintain that quality will get that mark that they can use. Now this mark will obviously be used in addition to their own trademark. For example, if I am talking of Darjeeling tea, okay, Darjeeling tea. Now Darjeeling tea producers must be having a GI mark. Okay, they will have their own mark showing that it is coming from Darjeeling. Now this all the producers of that region can use. Now imagine if Tata is there, Tata tea which is from is there, and let's say they are from Darjeeling. They are set up in Darjeeling. So obviously Tata will be the trademark. Okay, and a GI mark separately can be put up in which the Darjeeling tea logo will come. Okay, so very, very simple. So another more examples if you want, many other Mysore silk. Then I'm a little bit hungry, so let me look at certain food kind of things. Okay, so Orissa something it will come. Okay, later we'll see. Rasgulla, Odisha's Rasgulla is also a GI registered mark. So this is the GI mark. What it is? It's a GI mark. So Odisha Rasgulla, this is the GI mark. So moment I look at this logo, I know it is from Odisha Rasgulla. Whenever I look at this logo, I know it is a GI mark of Darjeeling producers. If I see this thing, it is the Mysore, sandal soap. So this will be there. So it is a GI. GI is basically an indication that the goods originate from that territory. So geographical indication. Indication means it is a suggestion, okay, that the goods originate from a certain geographical territory. Now very, very simple, when it will be rejected. Prohibition of registration of a GI. Now why we'll register? Just if you know registration procedure for anything, it is the same. Rejection procedure is also the same. If any mark, any GI mark is there, if it is scandalous, if it is contrary to law, if it is deceptively similar, it is similar to someone's trademark, it is obscene, it is hurting religious sentiments, okay, it is disentitled by a court, or it is a generic name, all this will be rejected. Simple. Okay, and also if it is falsely showing that it is not it is falsely showing that it is originating from another territory. For example, if someone Nagpur oranges are there, okay, but producers of a region who are there from another region are saying that it is Nagpur oranges when it is not. So it will have to be originating from that territory only, and you cannot give a wrong territory. Okay, that you give a wrong territory from another thing, I'll say. So the thing is, you also have to give the map, because very, very important. What happens is, imagine a very identical, a proper map has to be shown that from this much region to this much region only it is covered. So any producer outside this will not be able to use. Okay, so the region will be extremely clearly specified in the map. Okay, now let's look at the other thing. Registration of the geographical indication. Registration, section number 8. Very simple procedure. You make an application to the GI registry and before that also you do a search whether that mark can be done or no. So I have told you the process, it will be the same. You have a search whether you can use that mark. Then you give an application to the GI registry here. You will give to the GI registry. Then they will publish it in the journal. They will ask for opposition. They will appoint the examiner to look whether it is everything is okay. And then they will, after hearing all the objections, they will grant you. A geographical indication may be registered in respect of all or any of the goods. If it is coming from a definite territory in India, the registrar may also classify the goods into a certain. Now this also is common for everyone. Wherever there is a goods, the government can use. For example, if they are saying the goods are mangoes, So the mangoes, as per an international product classification, have a certain code number. That code number can be mentioned because in exports it will help. So for example, a laptop has a separate HSN code, Harmonized System of Nomenclature. It is a product coding system which is internationally used everywhere. So that can also be classified, and you can tell that, listen, with the product which I'm doing is this classification number. Okay, then application will be given. Now very interesting, section 11, who will give the application? Normally it is always the business owner who does. Here it is not a business owner. Here it is an association of persons who are coming from that territory, representing the goods from a certain territory can only apply. Association of person who are representing the interest of certain goods which are originating from a certain geographical territory, they can only apply. Okay, what all will the application contain? The application will contain the map, why it is so good, what is the quality, quantity, purity, reputation, how is it different characteristic, the class of the goods will be mentioned, the map, as I told you 100 times that it will come. Okay, a statement that this will be not a trademark, it will be a GI mark which all the producers can use. Normally what happens, a trademark only I can use, only the business owner can use. This mark will be used by all the producers of that region. Okay, now where will you make the application? To the GI registry. Every application will be filed before the GI registry and it will be examined by the registrar. Okay, simple. Registration, on registration you will get a certificate seal that this is your mark, congratulations, it has been registered. Okay, process, as I told you, it is same. You file an application, examiner will be appointed, it will be published in the GI journal, objections will be seen, opportunity being heard will be given, and then it will be registered, entry in the GI, and a certificate will be issued. This is a process same for all the intellectual property. Okay, so you don't have to worry. Once you do once, every time will be the same. Now steps for guide for registration process, same, we have done this. You can write it up. Okay, publication or opposition, this. Now very important. Okay, so very important, what is the duration of the, if a GI is registered, for how long do the producers get, and whether renewal is allowed? So yes, for 10 years renewal can be done, lifetime, and you have to pay the renewal fees. Okay, so section 18 says that the registration of a, very important, this is the most important part of the chapter, that how long will the GI indication, that mark will be the GI mark for a period of 10 years, renewed from time to time. Okay. The registrar shall on the application prescribed by the proprietor or the authorized user, whoever is there, will renew the registration of the indication. So registered proprietor means the original producers must be there, but the producers, let's say, over a period of time must have died, the original people must have died. Now their legal heirs will apply, provided they are from that region. They are called as authorized users. So very simple, that if mark is there, it will be for perpetuity. You know how members come and go. So producers who have filed it, have that area has got it, now producers can die, new producers can also use it, provided they are from that region. Okay, simple. So infringement, now this is also pretty interesting, section number 20, that if a GI mark is not registered and someone uses it, can you file for infringement case? Common sense that infringement is only for registered marks. So can infringement application be filed? Answer is no, if not registered. If you know little bit concept also, that infringement word is used only for registered marks. See, infringement of unregistered, you can do, easily use, anything happens, come to me. Okay, protection, because section 20 says that a person shall not be entitled to institute any proceedings, okay, for infringement of an unregistered GI. Get yourself registered, pay the government registration fee, then get protection. Otherwise, it will be infringed only. Now infringement of registered application. Now this you come. Section number 22. Anyone can come. A registered GI indication infringed if someone else has used your GI mark which is registered by a person not authorized, then obviously you can file a case. Okay. Either two things you can do. Either you can use the exact, now this is always same, either you use the identical mark or you use a similar or deceptively similar mark. Sir, what is deceptively similar? It causes confusion in the minds of the people. Identically same, but sometimes I use a little bit changes etc, but I keep the overall characteristics same that the people might come and buy. So if anyone is using identical or similar by means of uses any GI trying to show that it originates from their territory or misleads the persons or use it to constitutes an unfair act of unfair competition. That unfair competition means what? If anyone is using this mark or using similar marks or saying that it originates from that territory when it is not, so it is unfair competition. It's unfair. Okay, it means an act contrary to the honest practices in business. So the following acts have been deemed to cause unfair competition. So mark it as important. It has been asked in the past exam question also. Unfair competition with respect to GI mark deemed. So if I have used any act to create confusion, if I make a false allegation that the goods originate from that territory, if I am from Kashmir and I am saying that no, the goods are, these are Nagpur oranges when it is coming from Kashmir. So what am I doing? I am falsely representing that the goods are originating from another territory. Okay, or misleading the people with respect in any course of trade. It is called as unfair trade, deemed to be unfair competition. Okay, what is a registered indication said to be infringed? So when it is said that a GI is infringed, when there is an unauthorized use, okay, or there is an unfair competition, or there is a false representation of the origin. This I told you, all the three are very, very simple. So unauthorized use, unfair competition comes in when you're using deceptively similar or lying that it is coming from another territory, or falsely representation of the origin. Now another super important part, whether assignment and transmission is allowed for GI marks. Now pay attention, section number 24. Assignment means what? Can you give it to another person of another region that use this mark? So assignment is not allowed. Assignment means a person who is from another territory, geographical territory, I tell him that you use this mark. This is called as assignment. You transfer that right to someone else, not allowed. Transmission is allowed. Transmission means what? It goes by operation of law, it goes to the legal heirs. So producers of that region will be given for eternity till they are doing the payment. So father has, the producers of that region have applied. Now they died, now others have come, they will also continue to use the mark as long as they are from that territory. So prohibits, now pay attention, what does it prohibits? Okay, any right or geographical indication shall not be subject matter of assignment or transmission, mortgage, pledge or anything. So first they say no, it is not allowed. Pay attention. First they are saying not allowed, that any right of a registered person shall not be assigned, transmitted, licensed, pledge, mortgage by any other agreement. However, on death, as I gave you an example, death shall devolve around the successor. So that is allowed, which I told you. It's perfect. So transmission, assignment initially not, but death is allowed, which I gave, what I told is allowed. I mentioned that also. Very, very important. You can quote the language. Now difference between a GI and a trademark. I have given you, this is also a past exam question. A GI, a trademark is put on a business name, is a mark or a symbol showing that your goods and services are your product. Okay, it is given to a single product, to a single owner, to the owner of the goods. Whereas a GI mark is a separate mark for territorial, geographical location is mentioned, and it is not available only to the owner of the goods. It is available to a group of manufacturers originating from the territory. Okay, and the producers don't become owner of the GI mark. Means the producer cannot use it as a trademark. Okay, producer cannot you say that I am the owner. One single producer cannot say I am the owner. All of them collectively have a right to use. Now, as I showed you, Darjeeling tea had that had a GI mark. Can I use a GI mark as my trademark, my own trademark only? Common sense trademark is different, and Darjeeling tea GI mark is different. So, ideally, on a packet, you will have a logo of the brand, which is the trademark, and on that, you will have the GI mark also. So, if anyone is using a GI mark as a trademark, it is wrong. So, registrar shall, at the request, refuse or invalidate the registration of any trademark which consists of a GI mark. So, if someone is coming to register a trademark which is same like a GI mark, so they will say, listen, that is a GI mark, everybody can use. Trademark only you can use, so it's not allowed. Okay. Okay. Then offenses and penalties they have given you. Now see, just at least the main one we can learn, and main one only they have asked. Section 37 says a person shall be deemed to apply a geographical indication who, so anyone is said to have applied if he uses the logo, if he applies on the packages, if he applies on the goods, if he makes a reason, if he makes it likely lead to believe. Okay, it makes a confusion that it comes from there, advertises or shows a catalog, etc. with it. Okay, impressed, woolen, etc. Now, if you do all of that, then obviously they have put a penalty, and the penalty is not less than 6 months imprisonment, which may extend to 3 years, and a fine of 50,000 rupees, but which may go to 2 lakh rupees. Okay, so if you do a penalty for, so this is the 39 section penalty, you can remember. If anyone is doing anything wrong, contravention of the act, then 6 months to 3 years and 50,000 to 2 lakh rupees penalty. Okay. Now, one point is there, special provisions for citizens of convention countries. Now, convention countries, this is also common in every place. That India signs up so many treaties. India, central government has said that so many treaties we have done. Okay, convention treaties means a country with which we have done a convention, bilateral or UN treaties, treaty or convention we have done. So they are saying that if a person is if any person or a business owner is a member of a convention country, then he will get the same protection as he gives to us there. Reciprocal benefits will be given. So, in a convention country, for example, we'll do later also. Let's say if we have entered into any treaty. Okay. Now, with that treaty, if the foreign country, what benefits they give Indians, India will give benefits to their country. So member countries, simple, member or convention countries will be given same benefit. In simple lines, that if any country is giving benefits to Indians, the same benefit will be available to their citizens also in India. So India will also help you if you are helping Indian. So reciprocal benefits will be given if it is multiple countries. That is it. We've completed the entire chapter. Thank you. Okay. Clear till here? Yes or no in the chat box? Okay. Done. Okay. Chalo. Now we'll do another part. Okay. Now we'll do another part, which is, let's say, Copyright Act. Copyright Act, you know. Let's see. Equal pay नहीं है. Okay, great. Okay. So let's do one big chapter. We'll do one big chapter. Patents Act. Okay. Patents Act will complete. Now this is an important chapter, big chapter. Please be with me. We'll take a 5-10 minute break and then we will start with this chapter. Okay, if you do this, then everything else will also get easy. Okay, so heavy chapter we are doing, but it's going to be very, very simple. Keep your book and pen ready. Complete it with me. Okay, so Patent Act we will start. Maybe we give a, you know, 5 minutes or 10 minutes. No, 10 minutes will take. 10 minutes break. Okay. In 10 minutes we'll start with our important chapter called as Patents Act. Until then, you complete Part A chapter. So whenever I give a break, your job is to knock off one Part A chapter. So with Part B, you will also complete your Part A. Okay, so we'll be starting with the Patents Act. Okay, great. Breaks, I want you all to study your part A. Okay, so that part A and part B gets over at the same time. Chalo. Let's start with the Patents Act. Just give me a audible visible in the chat box so I can start and complete this topic for you. Audible visible in the chat box. So I'll start and complete this chapter for you. Quickly. Audible visible in the chat box. Quickly. Audible visible in the chat box or AV in the chat box. That's all. For me to know that I am audible. Great. Chalo. Faizan, Sona, great. So just remember 40 marks I'm covering for you. The balance 60 marks also I have taken almost 80% of the syllabus of that also. That also video I have sent. So during the break your job is to complete part A chapter. So simultaneously with me I'm expecting you all to complete part A and part B. Okay. So let's start. Hi. So we begin with the Patents Act. Now, when we do the Patents Act, let's look at the past exam question. So, the Patents Act 1970, section 54, they have asked, that is patent of addition. Okay. Then, if we go ahead to see what are not innovations, multiple times they have asked in the exam. Okay. Then, if I go to see, write a short note on compulsory license patent agent, they've asked, that's it. So, these are the exam questions. Sure. Let's start. So we begin with the Patents Act. Now, sir, what do you mean by the term patent? Now, remember what you will write. If someone will ask you, what is a patent? People don't know the definition or the meaning, only how to tell. So, patent is a right given to a person who has invented either a product or a process. Okay. So, patent is nothing but a right given to a person who has invented a product or a process. For example, if I say you have invented a laptop, you have invented a car, you've invented a particular air condition, you've invented even a small part of an engine, that's also covered. And even process patent is also covered. Process means how process is done. For example, water purification process. So if a inventor, we have inventor, you've seen those 3 idiots, that inventor, he gets a certain patents in his name. Moment you get a patent, you get positive and negative rights. Positive right is a monopoly right to use that invention to assign it to others for exploiting the commercial value of that invention. And negative right is to protect others from using it. Okay. So what does patent does? It is a legal certificate which protects your invention. So what do you mean by the term invention? Very, very important. So invention, if someone has told invention, so what do you mean by invention? Invention means there must be some inventive step and of industrial application. Means manufacturing process can be done. So if I say a car machine, engine, so it is you must have done some inventive step and it is of industrial application. So industrial application, patents, trademark, your designs are all industrial intellectual property rights. Okay. So a new product or process which has an inventive step. Sir, what do you mean by the term inventive step? Okay. So inventive step means that you have done a advancement, a technological advancement, which is not obvious to the person skilled in that art. So if a person is skilled in that art, for example, an engineer also, when you could say Steve Jobs, he came up with his iPhone, okay, iPhone, and he came with touchscreen phone. So what did he do? He brought a technological advancement, okay, to the existing knowledge. That time nobody had touchscreen or did not know about it. So he did it, and even the engineers were shocked. Even the people skilled in that art were shocked. So invention is a product or a process which has an inventive step. Now what is an inventive step? Means there's a technological advancement which is not obvious to the person of that art. Then they have asked multiple times, they have asked your, like how we have okay, they have asked what are not inventions also, they have asked. Let's see. Now remember one thing, when they use the word patentee, the patentee here means who the patenter is a government allows you the patent, and the patentee is the inventor. So remember, when I use the word inventor means it is the government is the grantor, here it is the grantee or the proprietor of the patent. So who is the patentee? Patentee is the inventor or the owner of the patent. Simple. Okay. And what do you mean by invention? Invention, as we saw, it is an inventive step and capable of industrial application. Simple. Now, what can be patented and what cannot be patented? Very, very simple. So for an invention to be, it should be new. It should be non-obvious. Now you can notice that, okay? It should new. It should be non-obvious to the person skilled in that art. It should have been new means it should not been published earlier. Not been published earlier. If anybody else is already using that machine, then you cannot come and invent it. So it should be new, non-obvious, and it should have an inventive step and capable of industrial application. This can be patented. But there are some items which are given in section 3 and section 4 which cannot be patented because they are not invention. So again, note it down that section 3 and 4 tells what cannot be patented. So first thing is, this has been asked multiple times in the exam. So if I am doing anything which is frivolous against government policy, against the public policy, it cannot be invented. Anything which is already publicly known, okay, contrary to public order, cannot be done. A mere discovery of anything, of any scientific principle, that cannot be patented. So for example, if I find out that gravity is a scientific principle, okay, it cannot be patented. Okay, common sense. Discovery of any new substance, animal, thing, they are discoveries. Okay, discovery of a place, it's not a invention which can be done to manufacturing activity can be done. Then a mere admixture, just mixing 2-3 things doesn't make it a invention. A mere arrangement, rearrangement, a method of playing a game, method of agriculture, this cannot be patented. Then any process for medical, surgical or treatment of human beings, this also cannot be patented. Plants as a whole, okay, a mathematical or a business method or a program, program per se. So computer programs do get copyrighted, they don't get patented. Okay. Next, any literary dramatic work, they all will get copyrighted. A mere scheme or rules for playing a game, Monopoly, your chess, etc. cannot be done. And a presentation, a PPT presentation, etc. cannot be done. A topography of integrated circuits, topography is the placement of integrated circuits, that cannot be done. Okay, invention which is a aggregation or a duplication of already known things or components cannot be done. Okay, so you can remember a few points from here. If you just see what all it is, some are points of frivolous, against public policy, a discovery of a scientific principle, mere discovery of a known substance, animal, admixture, just mixing of stuff, rearrangement, method of playing a game, method of agriculture, surgical equipments, etc. cannot be done. Mathematical, computer program per se. So just a few points you can remember is good. Section 3 cannot be patented, and even section number 4. Sir, what is section 4? Section 4 prohibits that with respect to atomic energy. For example, Hiroshima bomb cannot be patented. So a grant of a patent of an invention relating to atomic energy, Hiroshima, Nagasaki bomb that we dropped, cannot be. Fat boy, and one more name was there for an atomic bomb. fat boy and thin something, okay? So that cannot be used. Little boy and fat something, okay? Fat boy and little boy, something like that was there. Name of the bombs, that cannot be patented. Section 3 and 4 cannot be patented, they are not inventions, okay? So for a criteria for patentability, it should be new, non-obvious, inventive step capable of invention design and does not attract in section 3 and 4. Very, very important to know. Now, when we move forward, we look persons entitled to make an application. Now, if you look at a very simple thing, logically, who will come? Section number 6, okay? Who will come? So, inventor will come, inventor's legal representatives can come, or maybe if the inventor has sold his rights to a assignee, he is a assignee, he has sold it to someone else, the assignee will come. So, the true inventor, the assignee or the legal representative can come. Okay, now patent filing process. Now remember, they will give you a very long process. I'll cut it short and make it simple for you. Okay, now pay attention. Now a patent, when you have to give an application. Okay, that application has to be written, it has to be written, and you have to give the complete specification about it. Complete details has to be given about the invention. Okay, and it can be, okay, now it could be either provisional patent also. Now mark this as most important, this or, okay, I'm going to tell you the full process in short. I'm going to tell you the full process in short. Full process in short. Okay, so mark it as important. So very first, this they have not given there in the act, they start from here, but in reality, whenever anyone wants to patent a particular invention, okay, they want to patent an invention. So what they do is, they first they make a public research, a patent search will be done to see that if the invention can be patented, one, it doesn't fall under section 3 and 4. Then you will see whether it tests inventive step, whether there's nothing similar around in the market, etc. So that patent search will be done. After you are sure that, listen, I am very sure that this patent is this invention can be patented, then you file an application. Now, moment you file an application, and who will you file it to? I want you to learn this, okay, this particular thing, so that your entire process becomes very simple. When you give an application, you will give it to the controller of patents. Controller of patents. Now, moment you give it to the controller of patents, now he will say, okay, this is the invention. You have to describe the invention. You have to describe the invention. You have to give the best method of using it. What is the best method to use the invention? Okay, so that will be given. Let's say if I'm making air purifier is being made, so I'll describe that this will be called, a title will be given, called as air purifier. It can be used by so and so ways. Okay, what is how all it can be used, the scope will be given. The controller will be taken. Now the controller will then take 18 months to review it. The controller will appoint an examiner. A examiner will be appointed just to examine the invention more, okay, from the government side. Then they will publish it after 18 months. Now there are already so many applications pending with the government. Government says we will take some time to publish it in the patent journal. Patent journal, okay. So they will, by default in the normal route, they will publish it after 18 months. So then person will say, I have to wait for 18 months. The government says, if you want, I'll do it now only I'll do it. Within 1 year, I'll do it. So I said, take it and do it now. More fees has to be paid. Understood? More fees has to be paid if you want to publish it now. Otherwise, by default, it will take, after 18 months, it will be published in the patent journal. It will be told that this guy is saying that he wants a invention in his name. Then patent objection will be heard and examined, and then the grant of patent will be done. Patent will be granted for 20 years. How many years it will be granted? 20 years. After that, it goes in public domain. That means only for 20 years, the inventor can has an exclusive right to use that, sell that, and commercially exploit his monopoly right. So the monopoly right that he gets, and only he can use this patent, he'll get it for 20 years. After that, this will lose. Okay, then he cannot claim, it will go in public domain, then the entire public can use, rework, etc. So 20 years he gets the right to commercially exploit his invention. Now remember this application when we give, now I'm teaching you the full concept, so then I can go faster. Then you can build it in your own words, okay? Now when you give the application, the application could be provisional application, or it could be complete application, or it could be a complete application. Okay, what is a complete application? Means you give the full details of invention. Full details of the invention has to be given in complete. Now imagine if I am making I have in the beta version it is. Okay, so the product is in the beta version. So I don't have complete details. I don't have full details. So full details are not there. So that time at least I have some details. So at least that I will give. Now someone will say that if the invention is not ready, why are you giving provisional? I give at least part, because the date I file the provisional application, I get a priority date. That means if anybody starts using it, or I get a priority date. That means if anybody else comes, they will not be allowed granting. If from the priority date within 12 months I register the patent. So from the priority date I have to give the complete specification in 12 months. If I do that, they will give me the right and not anyone else. For example, let's say we are looking at January, February, April, December, etc. Okay, and now this we are looking of a provisional application. One key thing is provisional application has been given in one case. In the other one, complete application is being given. Complete specification. Okay, what word do you use? Specification. Sir, what do you mean by specification? It is the specs of the invention. Specification. Okay, the entire working, all the details of the invention. Specification will be given. Now understand that moment I'm working on an invention, it's almost done, I will immediately go and file it in February. So let's say I have given the provisional specification in February. Now I get 12 months time. So within 12 months time to give the complete. So I get till next Feb I can give the complete specification. And let's say I give the complete specification in December only, within 12 months. So here I give the complete specification. Okay. Now imagine someone, a competitor, it's a very highly competitive world, you know that. Let's say someone in April only has come with a complete specification of the same invention. Tell me in whose name it will be registered. So the answer is, if you have given a provisional specification and within 12 months you are giving the complete specification also, so this provisional application who has filed a patent will be registered in his name, and this will give you a priority date over others. So that's the purpose of filing. But always remember, whenever filing this provisional, within 12 months give the complete specification. Okay, done. Now let's look that the application form has to give specs. Specs is not just a detail, it's a techno-legal document. So crucial part of the patent application, means you will give details about the invention and the law together. Okay, so section 7 says every application for patent shall be of one invention only. Now, so it gives you this right, gives you protection of patent. Now one question is whether the patent that you get, whether you get a worldwide protection or it is only a Indian protection. So imagine if I apply for a patent in India, obviously I will be protected only in India. So if someone else is using my invention in another country, can I file a case? So ideally you would not be able to file a case, but now due to the patent cooperation treaty, now pay attention to this, what I'm teaching you, that in the patent cooperation treaty that you are allowed to file an international application. Okay, and this we have offices in Kolkata, Chennai, Mumbai, Delhi. Okay, any of them you file a patent international application. When you file, you get a protection in all the member countries, in all the convention countries. All the convention countries. Sir, what do you mean by convention country? All the countries which has signed the Paris Cooperation Treaty or Patent Cooperation Treaty, you get protection in all the member countries. Okay. Now, deemed Indian application if filed. Similarly, so what is happening is whichever country has filed a patent cooperation treaty, they get protection in India and we get protection in that country. So deemed application means if someone has filed a application there and applied for international protection, they get international protection in India also. Okay. Now pay attention to this, that for a foreigner, a USA inventor, first he will get he has to do registration in USA. He will file the basic application will be filed by him. This gives him protection only in USA. Then within some time he has to file an international application. Okay, international application. This gives you protection worldwide. In all the patent cooperation countries. Similarly, in India, first we do a registration in India, then we can apply for separately for international patent also. Now tell me one thing, will you file in international patent, will you file? You will say yes, but remember, if you register in India, you have to pay some fees, but if you want international protection also, then you have to pay more fees. So depending, not everyone will go for international protection. Okay, so every application under the Patent Cooperation Treaty designating India as the deemed, every international application under this stream is deemed to be a application in India, and they will get protection from the international filing date. So whenever they file the international application, they will get the protection. Clear? Now, same, remember I told you in section 135, same thing I have told you, that a basic application is filed. Basic application means that inventor has filed in that country. Then within 12 months of the basic application, he has to give his complete specification and a international application will be filed. Then he will be protected in India also. Okay, in all the convention countries. Now coming to what is a specification. A provisional specification is where you contain not the complete details, but you have to file a complete specification within 12 months from the date of filing this. If you do that, then you will get priority date and it will be registered in your name. If within 12 months you don't do, then it will be deemed that you have abandoned your application. Simple. Now, process I have told you, again I'll just take you through this. You can write in your own words, you're done. You don't have to go into depth and read everything. See, general procedure for obtaining, first you file the patent, it will be published after 18 months. So sir, why after 18 months? Government is saying before 18 months you want all to pay more fees. Okay, we already have a lot of applications. So patent journal will be published, then opposition will come, then a examiner will be appointed to examine whether there is a how is the patent, whether it is infringing others. Then it will be granted or refused. If it is granted, it will be published there, and then you will get protection for 20 years. Done. So very, very simple. What will be the contents of the specification? Section number 10. The specification will contain, I have told you this, that every complete specification will contain the invention type, best method of using it, the scope of the invention, and it will be in technical language. Simple. Okay. Then even if I am doing a biological patent means what? If you are inventing any specific thing which involves biological microorganisms, etc., like medicines, etc. Okay. When you want to patent it, then with respect to biological microorganism, when there is there, a Budapest Treaty has been made. Now pay attention, what is happening is just to protect microorganisms and have a separate testing thing, etc. A Budapest Treaty we have entered, okay, where they said that a deposit of microorganisms will be done, the verification, etc. will be done as per the Budapest Treaty. Just remember, whenever there's a microorganisms involved in any invention, okay, if you are making some medication where there is microorganisms involved, then it will be as per the Budapest Treaty, where they are made labs, etc., to check these organisms. Okay, so just remember that if the applicant mentions any biological material, okay, then that biological material will be deposited as per the International Depository Authority under the Budapest Treaty. So there is a separate authority internationally for this microorganism which will check. There, just remember that, everything else is good. Now it will be published, people can make an objection about it. Now very important is secrecy invention. That normally secrecy invention. Sir, what is secrecy direction? That if central government has said that, has directed prohibiting the publication of any information regarding a class of patent. So for any reason government has said that this I don't want it to be published for secrecy. So fine, it's a government order, then the controller will not publish that details, and the central government will keep reviewing certain things on regular basis. So what is section okay, and also remember one important thing, that in section 11 subsection 7 A7, that once you get the priority date, you from that date you have all the rights and privileges of a patent is granted. Like you can give it to others, you can use it, you can do improvement, etc., but you cannot file a sue anybody. Why? Because till it is not granted, okay, you cannot enforce your patent. For example, I've given the complete specification. I know that it's my product, so I can transfer to anyone, but I cannot file a case on anyone. Common sense. Only when it is granted, you can use that right to stop others from using it and file action for damages. Okay. After how much time is the application is published in the journal? So it is always published after 18 months. Okay. However, after 18 months it will be published, but if you pay more fees, it can be published earlier also. Then request for examiner, I told you examiner will be appointed to look into the particular application, whether it is violating or no, hearing both the sides. Okay, so now we are done with the process of issue and grant. Now directly we can come to the grant part. Now just remember one thing, that during the application, section number 19, okay, very important. Section 19, that if the controller feels that one invention which has come, it can it has a possible infringement on another patent, then while issuing the publication, they will issue a special notification to another person also, that the owner of patent number so and so, beware that this person is doing, do you want to object, come and object. Why? Because we feel that there is a potential infringement. For example, if Samsung has come, then, and we feel that it is very similar to Apple technology, so the controller while publishing, he will also tell that, listen to Apple, it is in that class, they have done, and he feels it is similar. So he feels that there is a potential infringement on Apple thing, so they will tell Apple that if you want, come and object. So see, in the consequence, if it investigates, the controller feels that an invention for which an application has come cannot be granted without a substantial risk of infringement on another patent. So if the controller feels that an application cannot be allowed till because there is a substantial risk of infringement to another patent, then he will tell that other owner, Apple owner, may direct the reference to that other patent, that you please come and this is the complete specification of this guy. If you have an object, come and make the objection. So then he will come, he'll write the words, reference has been directed under this section to patent number so and so, and then they will come, the other side will come and tell that the other patent should be revoked, or they will tell that the other patent should be amended, or if it goes to court, then depending on the court order he will decide whether to move ahead or to allow or no. Now patent opposition, everything we've done, okay, opposition will come, they'll hear and they will pass the order. Now very important is your section number 25, okay, mark section 25 is very important here, okay. Section number 25, opposition to patent. In the exam they can ask you a question that when can a patent be opposed. Now this is pre-grant opposition, obviously before granting you will oppose. So what reasons you can tell for opposing a patent? So I will say that it has been wrongfully obtained, like how in case of this Mark Zuckerberg, he said, the friend said that he has stolen my code. So a patent can be objected and asked for, you can oppose a particular grant of a patent if it has been wrongfully obtained, if it has been already published before the priority claim, okay, it is publicly known, it is not an invention, it is obvious and does not involve inventive step, okay, it is not an invention as per the meaning of the act, does not sufficiently describe the invention, has failed to disclose the questions asked by controller in section 8, it has not come within 12 months from the priority date, or it has not come within 12 months from the base application for convention country. Convention country first they file a base application, then within 12 months they give the full, or the application is filed. So that was also timeline is not mattered. If it is a biological waste, it did not disclose that thing, or it was not done as per the Budapest Treaty, it is already known in any place. So more or less the points are same and similar, okay. So if you go to see just some of the points, you can see invention is wrongfully obtained, it is already published, prior claim is there, invention is publicly known, publicly used, lack of inventive step, not an invention, not patentable, insufficiency of the description, it is a time barred application, disclosure is not made, disclosure of the biological material is not made, or the knowledge is already known in any territory, okay. So this you can do. Okay, after hearing it, you will pass an order. Now, very important, section number 43. Section 43 talks about the grant of patent. Now, patent, if you have, given a successful application, then and it is not found to be in contravention of the act, it will be granted to you. Okay, certificate will be issued. Now, conditions to be granted, that whenever you grant it in section 47, they say, listen, we are granting you a monopoly right, but whenever the government wants the machine or the process for government use, okay, or we want to use this particular invention for educating, imparting this, we can take it. So they grant you the patents, but they write this like this, star is put. What is a star? Conditions apply. They say that, listen, if you want this patent, we are granting it, but the machine or the process, the product or the process can be used by the government, or it could even be used for imparting education, or it can also be used for any drug. Rights of the patentee will always be positive and negative rights. Okay, then we see 20 years you get the right, we've seen. Date term is 20 years, and date of patent, if it is filed, okay, term of the patent, this also we have done 20 years from the date of filing the application for patent, and this is given in your section number 53. If it is an international patent, then, and which is coming under the International Patent Cooperation Treaty, you will get 20 years from the date of international filing date. Simple. In India, when you do from the Indian filing date, if international application has been filed under a PCT, then it will be from 20 years from the international filing date. Simple. Now very important is patent of edition. Okay, a patent of edition is given in your section 54, 55, 56. Now understand that if anyone has, now see, if an invention has come, they made an improvement. Okay, they made a IM, improvement or modification in main invention. So this also is included in main application. So let's say if the main application you had given for patent and it was registered and you get a life for how much, means you given an application for patent and you get a 20 years, you get protection, right? 20 years protection you get. During that 20 years, if you've come up with any IM, improvement or modification, you can apply here without any extra fees. That IM will also be included. For example, I have made a phone and I have just added one extra feature that can be added to your invention, right? You made an improvement modification, but the life will only be 20 years from the original, the main invention life will only be there. For example, in the 19th year, if I give the IM, then the IM will only be valid for 1 year. So the IM will only be valid till the life of the patent. Okay, so nobody can come up with the IM improvement modification also. So if I made a let's say air purifier, then I made an improvement modification, then during the 20 years that improvement modification will also be protected. That's it. So section 54 says, now pay attention, there is a IM on the main application. Provided the where application has been filed for a IM. What is IM? For an improvement or modification in the main application, in the main invention. Okay, then the controller may grant the patent of edition. So this is called as patent of edition. Simple. So these are the points, and all what I've told you is that only, that even if you filed a separate application for IM for as an independent patent, but you don't have the money to pay the filing fees, so you'll say please include it in this application only. I know that I'll get a lesser life, but I don't mind keeping it. So that also is permitted. Okay. Now, where the invention being an improvement or modification of another is subject to an independent patent. Okay, the patentee in the respect of that shall also be the patent in respect of the main application. The controller may, if so request, revoke the patent of improvement and grant a patent of addition. Thereof being the same date as same date of the patent so revoked. So for example, if you filed a patent and it is subject to independent patent, means you make something really new, okay, which could be separately registered, then you will say that my earlier application, scrap that and include this here only. So the controller may, if the inventor so requests, revoke the patent for IM. He'll revoke that IM application and he will say that grant to the patentee a patent of addition in respect thereof bearing the same. So simple. Let's see what they're trying to say. That if someone owns a patent for both the main and the improvement, then they can request the controller to replace the separate improvement patent with a new one called as patent application. Okay, so just remember that the IM is there. He can, if he's filed it separately, he can merge it here. That is also allowed. Not very important. Skip it. Okay. Date of filing. A date shall not be granted. A patent shall not be granted as a patent of addition unless the date of filing the application is same or later. Obviously, what will come first? Main application will come first or IM will come first? Main application will come first and IM will come after only, no? So the shall not be granted as a patent of addition for IM. Patent of addition will not be done for improvement modification unless the application is later than the date of the filing the main invention. Common sense. First I'll do invention and then later this will come. This is the sequence. Okay, so the patent addition Yeah. So simple logic is the patent of addition shall not be granted before the grant of the main invention. So first main invention will be granted, then the IM will be registered. Okay. So these are the points. Now term of the patent of addition. Now very important. How long will the patent of addition? What is their life? It will be equal to the main invention only. So how much ever time is for the main invention, that will be get, and you have to know you don't have to pay any renewal fees. Okay, for the IM. Okay, then let's see what is new out here. Restoration of lapsed patents. Market is important. Restoration of lapsed patents. Now what is this? That if now we had to pay, though it is 20 years, okay, though it is 20 years, but in 20 years 1 2 3 4 5 10 11 12 20, for example, full 20 years, government charges fees per year. Fees per year is charged. Okay, for the first 2 years there is no fees. Government does not charge fees, patent fees for the first 2 years. They say already at the time of filing you are paying some amount. We give you 2 years to exploit, get the customers, because your invention you want to give it to someone, you want to assign it, so that all takes time. So 2 years no fees is charged separately, and from the third year onwards fees is charged. Let's say in any particular year you didn't pay the fees. So common sense, no fees, no protection. During that time anyone can use the product and you cannot file a case of damages also. Okay, now if you not pay the fees, and your patents will lapse, and the world can use. Now if you want to apply for restoration of lapsed patents, then you have to apply within 18 months. You have to apply within 18 months from the time it has lapsed. Okay, you will apply for restoration. Once it is restored, from that onwards, if anyone is using, you can file a case of infringement. Let's see. Okay, pay attention. First, you have to mention what is the meaning of lapsed patents. It lapses due to non-payment of fees. So the payment of the renewal fees must be completed to the Indian patent before the expiry of the year. In case the patent ceases to exist due to non-payment of renewal fees, the patentee can offer restoration of lapsed patents. Just remember this, given in section 60. That section 60 provides that where a patent has ceased to have effect because of failure to pay non-renewal fees, then the patentee or his legal representative may, within 18 months from the date it has ceased, can make an application for restoration of lapsed patents, and it will be in form number 15. This point you can write and close it. Okay, procedure, what it will be? Procedure, obviously, go to file an application to the controller, pay the fees. The controller will see if there is any objections, and if anyone was wrongfully using it, you cannot file a case on that person also. So rights of patentee of lapsed patents which have been restored. So once it is restored, then from the date of publication of the application of restoration, cases can be filed. Okay, no suit, like protection fees you pay, then you will be protected, is what they are saying. No suit or proceeding shall be commenced in respect of an infringement of a patent which has been between the date on which the patent was ceased to have effect and the date of publication of the restoration. Means during the time when it lapsed till it was restored, during this time obviously the world will start using because it was lapsed. So no suit or proceedings can be filed. Now surrender or revocation of patents. Now common sense is, if the surrender is voluntarily done by the owner, if he feels that nobody is using it, he can go and surrender. But before surrendering also, controller will publish it that, listen, this guy is coming to surrender. Does anyone have an issue? That will be done. Okay, objections will be taken. Now difference between surrender and revocation. Revocation is when you have done a violation, someone has filed a case and the controller is cancelling it. So controller does revocation, surrender is voluntary. Okay, one is done by controller, the other one is done voluntary. Okay, grounds for revocation of patents, very very important. When the patents can be revoked, the common sense, if anyone proves that they had a priority claim, they had already issued it, patent is a patent application by an ineligible person has come, it has been wrongfully obtained, it is not an invention, it is already publicly known, it is obvious and lacks distinctiveness, it is not useful, it has not given full complete specification. So the issues are more or less common, the scope is not clearly defined, false representation has been given, item cannot be patented, okay, it is under secrecy direction of government, okay, false information has been given, fraud, etc. Okay, non-disclosure of the biological material. I told you biological material, when you do it, goes as per the Budapest Treaty, and there is a separate depository only made to check biological, and it is known in any community. Okay, and one line is there that no secret trial can ever take place, means the controller cannot have a closed room, they always have to keep it, public. Then working of patented invention, general principles, means what? If anyone is, when we are granting you patents, the objective is to honor the inventor, that you go ahead, you can exploit your patents and commercially earn. Okay, the following conditions will be given, that listen, we are telling you that we are giving you patents, working of the patents will be given provided the purpose of granting is to encourage invention. It is not only to give you monopoly, you should help the public, you should not hamper the public health, you should not, it does not prohibit the right of the government to use it. Okay, it shall not be abused by the inventor, and it should be available at fair prices in India. So these are some of the general basic principles why government is giving, and they expect from the inventor to use it and give it to the public at fair prices. Which brings me to one point which is called as compulsory license. Now compulsory license is given under section 88, 84 to 92. Okay, compulsory license is a compulsory permission given to a third party by the controller to sell, use, etc. the patented invention without the consent of the owner. In this, what happens, compulsory license, imagine if the owner has made a, this is very rarely used, and it was used once in Bayer versus Natco, where a cancer drug was involved. So you will write that initially that patents are granted so that it is used in India and given in India at affordable prices. Now these cancer drugs was made at an extremely high price in India, and they were mostly exported. So then what happened is, one of the companies said that listen, this cancer drug is very very important, please, they wrote to the controller that give us the license, okay, to use this invention, because the owner is not listening, owner is acting smart, charging more, etc. Okay, he's creating artificial shortage. So then in public interest, the controller can give the rights of manufacturing of that patented invention to any third party also. This is called as a compulsory license, and this can be made, section 84 says that compulsory license can be given after 3 years from the date of the grant. So 3 years you earn how much ever you want. After 3 years, the controller has a right in public interest to grant compulsory licenses. When it will be done? When the needs of the public is not met, the patented invention is not available at fair prices, and it is not worked in territory of India. Means you're not selling it in India, you're selling at very high prices, and the needs of Indian public is not met. Then we say that your invention we have granted, this right of manufacturing will give it to another person. Now a compulsory license has been given. So when a license has been given, the inventor can use it, but additionally this other person will also use, and the controller can tell certain amount to be paid to the original owner also. Okay, they can tell that some fair amount can be given. Okay, so the controller, when he is satisfied that the patented invention is not satisfying any of the conditions, that is not used in India, not available at affordable prices, he will grant the invention. Okay, they will look at various things before granting the invention. That's it. Okay, this is the main point. So all compulsory license only, but same points they are saying. Okay. Yeah, and very important is, remember, international applications all have the same concept in entire all the IPRs laws, that if you are if a person is a member of a convention country, if that convention country is giving benefits, grants, rights to Indians, then that member country person will also get the same rights in India. Reciprocal benefits for international application. Remember this. So if those countries are helping Indians, we are helping their people. That's the point. Now, patent agent help in signing, filing, giving advisory services. Okay, normally there's a patent agent exam, but we don't have to give it. Okay, why? Because we all are falling under the patents agent category. So there is an examination. Certain lawyers, etc., can be covered here directly. So the controller of patents, okay, the controller of patents, designs, trademark. We have done this. Okay, they are the controller for patents here. Okay, the office is the head office is in Kolkata, and there are other offices in Delhi, Chennai, Mumbai also. And appeals, normally earlier used to go to the High Court, now it goes to the intellectual property appellate board, and the appeals are made within a span of 3 months. So if any person is not happy with the decision of the controller, they will go and appeal to the intellectual property appellate board. First High Court was there, now those powers have been shifted to the intellectual property appellate board. Okay, with this we have completed the entire chapter on patents, including the past exam question and all the important topics. Thank you. Clear till here? Yeah. So we've completed multiple topics. Okay. Now we'll take up one more. Only one important chapter, copyrights. We'll see copyrights and complete that also. Okay. So whenever I give a break, your job is to complete 2 chapters of part A. Your job, so simultaneously you'll be able to complete everything. Okay. So is this clear till now? Yes or no? Write clear in the chat box. Just write clear in the chat box if this is sorted. Write clear in the chat box. I can quickly complete this also. Okay, great. So more or less, if you do all of the chapters together, it becomes very simple. Okay, we are almost done. So we'll just take a 5-10 minutes break and we'll be back. Okay. Till that, you complete some other chapters and keep. Okay, so am I audible and visible, guys? I need you all to tell me in the chat box so I can quickly start and complete the chapter. Okay, just you all have to message audible and visible in the chat box. That's all. Okay, audible and visible in the chat box quickly. Or AV also you write is enough. Okay, so I can start. Okay. Okay. Am I audible, visible in the chat box quickly? Okay, great, great. Chalo, let's start. Okay. Hi. So we begin with the copyright law in India. Now, before we start, let's look into the particular provisions of what questions have been asked from the Copyright Act 1957. So the first one they have asked is about Section 19, assignment of copyright work. Okay. Then they have asked, okay, is explain the provision of power of police for seizing the infringing copies under Section 64. Then they have asked section, yeah, so these are the questions that they've asked for your copyright. Okay, let's see. Now let's begin with the act. Now what do you mean by the term copyright? Now copyright is covered under your chapter under your act 1957. Now copyright is a right to a person to copy his own work and to prohibit others from using the work. Now copyright exists in, you will write that copyright is a right to copy your own work, reproduce it, assign it to others. It gives you a right, a positive right, that is to use, assign it to others. Even if you want, you can destroy it. Or a negative right is to prevent others from using it. Now copyright exists in C square AL. Okay, copyright exists in computer program, cinematic graphic work like movies, then artistic work like your paintings, and literary work is like your writings. Okay, so just remember that the copyright for all these things you will do a particular registration of copyright. So maybe a computer program, C is for cinematic graphic work, A is for artistic work, and L is for literary work. Okay, so copyright exists in, you will write copyright protects C square AL. Okay, it gives a exclusive right to an author to do something and to protect others, to restrict others from doing something. Now that we've understood, every type of copyright is protected for a different time zone, okay, for a different tenure, which we will see. Copyright of cinematographic work is protected for another time period. For artistic work is protected. Your broadcasting rights are protected for different work. Let's see. Now, as a copyright owner, okay, you have multiple rights. That is, a positive right is to copy your work, use your work, or adapt to that work also. Okay, so adapt to their original work. What does adaptation mean? Adaptation means that you are making changes in your work. Okay, for example, if a particular let's see, adaptation could be you have made a movie, now you made let's say a sequel of it, so that's an adaptation to your work. Let's say sound recording, you had a music, okay, and now you made a remix of it, so that is also adaptation. For movies, remixing of songs, novels, etc. Now Adaptation can further be called that from a movie you made a from a book you made a movie, or from a movie you made a book. That is also allowed. So dramatic work can be converted into non-dramatic work. So dramatic means drama or Shakespeare play can be made into a particular novel. Literary work can be converted into dramatic work. So from a book, a movie has been made. So these are all adaptations that you have done. For it was in one form, you made it in another form. Pictorial versions can be made to other dramatic work. For example, from a book, I can make images for children, etc. That all will come here. Okay, you can modify, remix your entire make any changes in the songs or the musical work that you have, or alter the work in any other way is called as adaptation. Common sense, it's a English word. Now when I say communication to public, for example, if I have a copyright, I have a right, positive rights to use it, to give it to others, that is assign it, to restrict others from using it, that's my negative right. I also have a right to publish it to people. Even your copyright, let's say in YouTube videos, you have a right to broadcast it to public. One. Second, let's talk about communication to public means what? Means you're making it directly available to the public to your. Communication to public means any work or performance being enjoyed by public directly is means making communication to public. So any song, any movie, any live concert, you have the author has a right to even communicate it to a larger audience. That work is called as broadcasting. Even sound recording comes in copyright. For example, a song, okay, as I told you, cinematographic work contains sounds also. So sounds, rhythms, anything can be copyrighted. Then author. Now when I say author of a copyright means what? Author of a copyright means the owner. Now as I told you that copyright exists in C square AL. C square AL. So then you say author of cinematographic work means what? Someone who has made the movie, or the producer of the movie or the song. C square, computer program. So if it is a computer program, then the person who has made the computer, okay, computer work, etc. Then the person who has created that work. C square A artistic work. Okay, artistic work, if it is there, then the artist obviously is the owner. If a photography is there, then the photographer. C square AL, literary work is there, so the author of the book. Common sense. Okay, dramatic work is the author of the work, is the author of this definition of the term author. Okay, now remember, section 13 talks about conditions for copyright eligibility in India. Common sense, just forget about copyright. Any intellectual property in India, you will get protection and registration if it is the original work and it has been registered in India, or it has been done anywhere in outside India. So it is all allowed. So copyright shall not subsist in any work specified in subsection 1 unless, this is simply saying conditions, okay, that if the following conditions are fulfilled, copyright will be given. So common sense, that it should be published. In case of published work, it has been published in India, or it has been published outside India, but the person is a citizen of India. And this applies even if the author is deceased. Means simple that it is copyright we are talking from, you're getting registration in India now. So either you have published the work first in India, or the author is a Indian citizen. So maybe if I have made a song and I put it on YouTube, so it has been published in India, so it's called as published work, it can be registered. Or if I am a citizen and I've gone outside, I've created my work, so I come back in India, tell Indian government, listen, I am in Indian, so please register it. Okay, even it applies even for a deceased. For example, if a person died while making a book but he could not publish it, his children identify that this person has done. Like Michael Jackson last song was published posthumously after his death. Unpublished work also, they are saying that unpublished work, the author is at the date of the work a citizen of India or domiciled in India. So mainly they are saying that it's an Indian act, so Indians will be available, or it should be published in India. Then only copyright protection will be given. For architectural work, if the work is in India. So copyright work for architectural work means what? Any kind of design of a bungalow, etc. It's an architectural project. Interior designing, they make those layouts, so they all get copyrighted. Simple. Okay. Now, meaning of the term copyright. Now this I made you learn only. Now I think you will also be able to tell that, and that is your section number 14. Section 14 says that copyright exists in C square AL. Sir, what does C square AL mean? Copyright is an exclusive right. Now if someone tells you what do you mean by copyright, so you'll say copyright is an exclusive right to do or to authorize others to do or to prevent others from doing any of the following work. C square AL. So C square is what? Computer program, cinematographic, artistic and literary work. So literary work, computer program, okay. Then computer program is here, then artistic work is here, then cinematographic work is there, and then sound recording. In cinema you see movies and songs, na? Both will come. So that is it, concept done. Now in the left hand side they told you the particular what it is, and here with respect to that work what all will you do? So I will reproduce it, I can make copies, I can make it available to public, okay, I can translate it, adapt it, common sense, all you'll write. For all the others you'll write the same points. Okay, done. Now interestingly, your copyright term, the rights in which you have, okay, is not infinite, it is a limited time zone, and depending on which C square AL it is there, C square AL, your tenure changes. Means for computer program is different, for artistic work it is different, for literary work it is different, for broadcasting it is different. So we will see, but most common one is 60 years. What you'll remember? 60 years. So today I have written a book, so then I will get, the book is protected for life of the author plus 60 years. So this means to say even after the life of the author, 60 years, the children will enjoy the royalty. So any kind of artistic work, etc., this will be there. Even if a person is dead, okay, posthumous work is there. So 60 years from the date of the publication will be given. Michael Jackson, while making his last song, died. So moment it is published, 60 years, the children can enjoy. Posthumous work is covered. Cinematographic work also 60 years. This is also 60 years. Almost everything is 60 years from the date of publication. Simple. Okay, 60 years you will remember. Now what is not 60 years? And copy, you can write this line also. This symbol comes when it is a copyrighted work. Simple. Now just remember, for broadcasting it will come later that it is 25 years, which we will see. Rest mostly it is 60 years only. Now assignment of copyright. Copyright means what? That I have a right to copy my work, to duplicate my work, to adapt my work. Okay. Now assignment is given in section number 18. Assignment means a transfer of right. Okay, that transfer of right, I can give it to someone else. I can assign my right for royalty. I will have a written agreement. I will have how many adaptations, whether it can be done, terms and conditions will be written. It's obviously given to another person, and that I am the assigner, and that other person will be called as the assignee. So the copyright owner can assign their work to other persons. Okay, they can cover the entire copyright term or a part of it. So I can say you keep it for full 60 years, or I can say for 1 year, 2 year, my wish. Okay, that is there. I will tell them how the medium of exploitation, how many times, whether it's for how much, where all you can use, what all you can use, whether you can do adaptation, improvements or no. Okay, and in return you get royalty. Okay, even for cinematographic work, etc. Okay, that is there. Now, mode of assignment, how will you assign it? Obviously you will have through a written agreement. In the written agreement, you will contain all the terms and conditions, which is called as a specificity. Territorial extent, duration, all of those will be done. Okay. If the assignee does not exercise the rights within 1 year from the date of assignment, it will lapse. Means if you have assigned it, he has to use it. If he doesn't use it, it is 1 year, it will lapse. Now, disputes. Any dispute is there will go before the copyright society. And you can revoke if dispute is there, the owner can revoke also subject to the agreement. Now, remember this compulsory licensing is also there in patents. This is also the same thing here also, that if at any time the copyright owner is not using the copyright material in India, or they are not using it at fair prices, then any complainant can come, inform the controller that this guy is not giving me a license, it is needed in public, and if the controller feels that this license is needed to be given, then mandatorily they will tell that the owner is there, he is not acting smart, so we will only assign it to a third person to use it for the benefit of people in India. Okay, so section number, this is not important in patents, it is still important. Section number 31 says that at any time during the term of the copyright, a complaint is made to the court that the owner is not using it, not publishing it, okay, and it is withheld from public. So they will say, what nonsense, you are not using it for public or not broadcasting it, etc. Then after giving the owner the opportunity being heard, the registrar can grant a compulsory license. Now, understand what is a copyright society. Now, an individual author, a singer, etc. cannot keep a track of all his songs, who needs his songs, etc. So, what happens? Now, just imagine today, if there is a singer, okay. Now that singer has made so many songs, he's made many songs. Now, so many companies would want to approach the singer, okay, to take his work. In return, they will give royalty, and the singer will then assign them the rights. But what happens is, to find these singers, all the different singers are there different times, how it becomes very difficult. So what happens is, a copyright society is made, okay, where the copyright owners like your singers, performers, etc. will give their rights to the copyright society, that you deal with others. So whenever there are a third party or companies there, when a company is there, they will contact the society, okay, and they will pay the royalty to the society, and the society will then give it back to the owners. Okay, they will distribute the copyright work, do the negotiation, do the litigation if there is violation. So what happens is, these owners, they make their own society, they pay membership fees, okay, is given to the society, and all the singers will make, all the dancers will make, all the movie makers will make their own society, and then that will help get royalty to the people. Okay, so an individual cannot cover his work, so they make a society to look after their collective interests. Authors give their right, these societies to the society to look after their interest. An author becoming a member of the society can then their work will be, they will grant the work to the society, who will further grant it to all the people who require, others who require this thing. Function of the society. So what does this society do? They will license the work, they will collect the revenue, and they will distribute. So they will license the work to others, they'll collect the revenue and give it back to the owners. Okay, so we have all these societies in India, producers of India, singers of India, etc. Okay. Now come to broadcasting right. Now broadcasting right means what? There's so let's say a cricket match is going on. So now cricket match is being conducted by the IPL or BCCI, etc. Right? Now what happens? All these rights to show this match, you see, it is not allowed to be shown on YouTube or any other channel. These broadcasting rights means a right to broadcast, right to communicate to a larger audience. I give this right, take this match is going on, you can broadcast it further. Okay, so bids are taken by IPL that how many companies want to take these rights. So they all will give the bids, and then the bids will be the highest bidder will get these rights, and then they will play it on their channel. Okay, so rights of broadcasters are very, very important, or performers right. So even if let's say there is a singing performance or a dance performance, or a foreigner who has Black Eyed Peas has come into India, or we had this recent concert was held by one more band. Who was that band? Guns and Roses, they had come. So what happens is in Goa they have so many concerts. So section 37 to 39, okay, of chapter 8 talks about broadcasting and performers' rights. So the performer is performing. He has his rights. A match is being played. They are performers. So they give this right to broadcast, to rebroadcast, to make small clips, to get everything. They say you take this, give me so much money and you do whatever you want. Now this broadcasting rights they get it for 25 years. So the broadcasting reproduction right shall be for 25 years only. Normally how it was there 60 years, this is 25 years. So it is a special right to broadcast it to a greater audience. Okay, exclusive right. So what all rights do you give? A right to rebroadcast. Once you play, then you play the replay, then you play the highlights. You can make paid viewing also. You can put it wherever you want. Right of recording. You have a right to preserve a recording, backup. You have a right to protect others from negative right of preventing misuse. Unlicensed work should not be done. You have a right to commercially distribute. You can further give it on rentals also to others. Now performers right. So we saw broadcasting right is 25 years. Now let's see performers right. So performer, who is a performer? Section 38 provides that a performer could be singer, snake charmer, or magician, or any dancer, etc. Where any performer appears in any performance, he has a special right called as a performer's right. So a performer has a performer right over his performance. He has a right for 50 years. Okay, from the beginning of the calendar year next following the year in which the performance was made. From whichever year it is made, from next year till 50 years, he will have that right. Exclusive right, obviously you get a right to make a sound recording of your performance. Okay, right to issue it to public, right to communicate it to public, right to give it on rentals, etc. Now performance royalties. Now obviously when a performer will want to give it to someone these rights, so then he will enter into an agreement, okay, and he will get royalty for the agreement. Now very, very, very important, okay, very important, is called as a moral right of performer. Now moral right of performer means what? Do you know? Now this is a very favorite exam question, okay. It comes under section 38B. Now moral rights of performers is available to the authors even after the economic rights are assigned. So even after assigning it to someone, I imagine I've transferred my rights, still I have some inherent rights. These inherent rights are called as moral right of performer. So moral right of performer is if I have given my rights to someone, I still have some power over these rights. So it states that even if a performer has assigned all or some of their rights, they still have the right to be credited as a performer. So let's say if a book has been written from my thing and I'm a performer, so I should get the credits. The credit should be given to me that it has been performed by so and so. The right to object and seek damages if there is a change, distortion, mutilation or modification of their performance. So if someone does any editing on my work, then I have the right even if I've given it to them. So it's not that if I give my rights to someone then they can twist and turn and make some parody video out of it. So anything whichever damages my reputation, I still have those rights even if I have given an assignment to someone. Okay. Now remember, for foreign rights, for protection of foreign work. It is common. Section 40 you can remember. And remember the word as reciprocal basis. This is same for all trademark, copyright, patents, that the benefits will be given on reciprocal basis. That is, if the foreign country, if this you will write in all the acts, okay, if the foreign country grants similar protection to the work protected by to the works protected by the Copyrights Act of India, means if our copyright if Indians are protected in that country, then those citizens of those country will be protected here. This is as per the international copyright order here, and this was same thing mentioned in Berne Convention and all the convention that we've entered with this. Okay, Berne Convention, that if a work has been published in their country, it will be treated as it is published in India, provided reciprocal benefits have been given. Okay, this is the entire thing what has been given here. Then copyright registration. Now obviously to register you can apply it online also. It will be published. Okay, it will be published, objection will be taken, and then the this will be given, the copyrights will be given. Any disputes, now registrar of copyright is there. Okay, registrar of copyrights, they have all the power of a civil court for summoning, enforcing affidavit, issuing summons, examination of witness, everything they will have the same powers. Okay, procedure, you give an application and after objection it will be given. Infringement of copyright, now very simple. If there is an unauthorized use of the copyright work, it is called as infringement. Or registered work, that is called as copyright. Types of infringement means what all must have happened. So either someone is selling, even someone is distributing, if someone is put for public exhibition, somebody has imported my work, etc. Okay, so we can ask for the infringing copies. Means if there has been a movie has been pirated and there are 50 CDs, so they are all called as pirated CDs, are called as infringing copies. All of that can be, or I can get an injunction for all of that. So what are the common copyright infringement? What do people do? They either make and sell, they display without consent, they distribute copies, infringing copies, okay, pirated copies, they put up a public exhibition, or they import into India all those the owner's things. Now owner's copyright work. Now very important, statutory exceptions, certain acts which not to be considered. So very important, certain acts which will not be considered to be infringement. So some work they have told that this is not infringement. So suppose if I am dealing in fair dealing, for example, I don't have any commercial intention, I am just reading a book and I narrate it online, not a violation. I am educating students, not there. Then if I am using the computer software, it is not there. If simple points you can take from here and close. I'll tell you what is important. So all this is not infringement. Okay, so taking a copy of it, I'm not doing commercial purpose, educational purposes is there. During instruction of students, it is not there. Educational performance is there. Another thing, playback, public playback. For example, a song is copyrighted, but if I'm just playing in public without any commercial things and everybody is dancing in your house party you're having, you can use it. Amateur clubs. Okay. Now most important. Now this is the most important, from which question sometimes is framed, that limited copies for non-commercial libraries. So if a non-commercial library is there, they can make up to 3 copies of a book if that book is not available for sale in India. So let's say if a particular book, medical book, is not available for sale in India, so the non-commercial library, means they are just opening it for reading, they can make up till 3 copies and keep it there. Why? Because they'll say it's not available for sale also. So keeping a book in the library is not a violation, okay, as long as it is not available for sale in India. That is why. Research is allowed. Okay, translation of legislative acts in Indian languages is allowed. So act is there, I convert into different languages is allowed. Okay, making sketch of anything. For example, if Taj Mahal is there, I make a sketch of it, it is allowed. Okay, so general stuff they have given you, it is all allowed. So you can read it up. Okay, and then they've given you a just penalties and protection of the rights of management information. So electronic rights management information. Okay, ERMI, electronic rights, refers to data attached to digital files to control their use in order to protect the intellectual property of the content creators. Okay, example, the ebook can be read only up to 2 devices. You cannot copy the book from the text, you cannot share the ebooks. So basically they're saying that for uh, electronic rights, okay, data attached to the files is also protected. So for example, if you go to see that if you're taking some online subscription of any educator, okay, that time the files can be protected. It will be written that only 2 devices can be used. So all those digital limitations can be put in. So your electronic rights can be limited by the owner for protection. Prohibiting from the printing the ebook is disabled. So all these technologies are there. As per section 65B, any person who knows unknowingly removes or alters any rights. So anyone who knowingly knows that these rights are there and he tries to tamper with these rights without authority, okay, shall be punishable, which may extend till 2 years, and also punishable with fine. Okay, right management information means the title, identifying the work, the name of the author, the terms and conditions of the rights, etc. So, right management information. So, let's say if we have written a book and that it is written copyright Jahangir tutorials. Now, someone goes and unlocks the book, converts it into another thing, and writes copyright their own work. They will mention. So that is a violation of the copyright. Simple. Then they've given you few punishments. Some of them you can read up. Okay, with this we have completed the entire chapter. Thank you. Clear? So we've covered everything including the past exam questions. Clear? We've completed everything including the past exam questions. Now let me see if we have that. Okay, just write clear in the chat box till then. Just write clear in the chat box. Just write clear in the chat box. If you not like the video, please like the video. It's a bare minimum I expect from you all. Okay, share it with your friends, etc. Okay, someone's helping you to pass. Okay, great. Thank you. Okay, so we'll start the last chapter in 5 minutes. 5 minutes and we start the last chapter. Okay. Okay. So am I audible, visible quickly? So I'll complete this chapter for you. Okay, great. Let's start. Okay. Lesson 15. Okay, let me know in the chat box if I'm audible, visible. Lesson 15. Okay. Quickly, AV in the chat box. I'll start and complete it for you. Okay. Great. Just write AV in the chat box so I can start and complete it for you. Okay, so I'll come to know that I'm audible, visible, and I can enter lecture. Great. Hi. So we start with lesson number 15, your intellectual property. Okay, your intellectual property rights. Now this chapter is to be done last, because once you've done all the other chapters, this chapter is just, they're going to contain all the small parts from all the other chapters. But what is needed to know additionally, let's discuss in this lecture. So very first thing is, they talk about intellectual property. So intellectual property is called as the creation of the mind. So we can call it as the creation of the mind. Creation of mind. Now intellectual property is divided into various categories, where the two broad classifications one can do. It is intellectual property, that is creation of the mind. Creation of mind. Okay, it is classified into two: industrial property and non-industrial property. Industrial property is those which can be going into manufactured, like trademark, patents, designs, geographical indications. Whereas non-industrial property is your copyright. For example, your books that you've written, computer programs, etc. will come here. Okay. Now, in this chapter, they talk about what does a inventor, or maybe a person who owns IPR, intellectual property rights. They have two rights. Okay, one is your positive right, and the other one is your negative right. Positive right is the right to use, right, to assign it to others, give it to others, or to destroy the goods is your own right. Negative right is to prevent others from using it. Okay, now intellectual property rights is the backbone of the economy, because it encourages inventors and creators. It helps the creativity of any country, because once a right has been given, they are protected. They can exploit that IPR, intellectual property right, commercially exploit and earn money from it. Okay, now there are various acts. Okay, intellectual property rights can be divided into 5 acts, that is trademark, copyright, patents, GI, and Designs Act. Okay, which is the chapter that we have. Now, if we go to see the particular here, they are going to talk about certain institutions. So the institution that we have to know about is these. Okay, now you have your WTO agreements, the GATS, TRIPS. Okay, so the very first agreement, that was entered was GATT. It covered only goods. Only goods were covered. Then they had said that we should have another agreement for services also. So then the services was covered, and that time even WTO was formed. So your WTO and GATS is there. So GATS was a part of WTO, World Trade Organization, which is there. They had made GATS also, where they said that goods will also be covered and services will also be covered. And then later we had TRIPS. TRIPS was trade related aspects, okay, trade related aspects of intellectual property rights. So trade related aspects means it covered everything: trademark, copyrights, patents, GI, okay, everything was covered. And they said that we should have something, for dispute settlement mechanism should be there for your intellectual properties. So let's read. So the WTO covers both goods, services and all other kinds of intellectual property. So WTO is applicable even today. WTO is applicable even today. Now it was created on 1st Jan 1995 as the biggest reform in the international trade since the World War. Okay. GATT was covered only goods. WTO was formed in WTO. Inside WTO, they had GATTs, which said that services will also be covered. And TRIPS is general for everything. Let's see. So these three we need to know. GATTs was the first one. It covered only goods. This was a part of WTO and it covered services also. And trade related aspects of intellectual property covered every single thing of all the kind of intellectual property and a little advancement on those also. Let's see. First, when you see how did it come into force. So this entire thing came when the World War ended. Okay, the World War ended in 1945. Now imagine moment the World War II ended, that time what will be the scenario among countries? Nobody will trust each other, and international trade was majorly impacted. Okay, then all the countries came together. They made a general agreement on tariffs and trade. They made an agreement called as General Agreement on Tariff and Trade right after the World War. So this was the very first agreement that was made. So if you see, the World War ended around in 1945. This agreement was made after 2 years later, and it was signed by 123 countries and it was held in Geneva. Okay. Now it covered only goods. This covered only goods. Then the government entered into WTO. WTO was made. WTO was made. Now WTO was made in 1995 in the Marrakesh. Same 123 members were there. It replaced GATT. It replaced GATT. Okay, so GATT was replaced by WTO. In WTO, you have to remember that 1995 it was brought in here. And what does WTO do? It regulates international trade. Okay, it replaced GATTs. Okay, and it also, a part of WTO had GATTs also, that we will also talk about services. It was in the Uruguay round, and you'll see in 1995 only it came into effect with WTO, and it had same 123 member countries. Okay. Then came WIPO. Okay, what was WIPO? It was World Intellectual Property Organization. Now what was this? Now when I say world means what? They wanted that it was about intellectual property. So moment they say you will write about everything. Trademark, copyright, patents, everything was covered. And world means they wanted that intellectual property should not be protected only in that country. It should be worldwide protection should be given. That is why they've used the word worldwide. So worldwide international patents, etc., patent cooperation treaty had come here, etc., which we had studied that international protection can be given. Its headquarters in Geneva, Switzerland. Okay. And you see that patent cooperation treaty, etc., was passed here. And then you'll say worldwide protection. You can mention that. Okay. Then came TRIPS. Now see this, that trade related aspects of intellectual property rights. So moment they say IPR, you talk about all the things, goods, services, trademark, copyright, patents, you can mention about that. And trade related aspects means what? They wanted a proper dispute set. A Uruguay round, it was held, negotiated at the end of Uruguay round in the GATT, where they said that they should have some dispute settlement system. Okay, they wanted a proper trade related issue should be resolved. Okay, proper manner of payment, etc. should be done. Like they covered everything. You can mention this, like this covered. Whenever they say IPR means trademark, copyright, patents, industrial designs, everything covered, and even trade secrets. Okay. Then concept of intellectual property. Now they will talk about your trademark, patents, copyrights, which we have done chapters on. What we need to do here is GI is also covered. There is one small little part of trade secrets. Okay, this they had asked in the exam. What is a trade secret? A trade secret is something which is not widely known. It is a information, okay, which a company has, which gives them a competitive advantage over people. So trade secret is a secret that you have maintained. Like Cadbury must be having a trade secret on how it is made. It is not disclosed. It gives them the competitive advantage. It is preserved indefinitely, and it is must be of significant secrecy is there, and it is difficult to maintain and preserve. Simple. Then comes the national policy IPR. Now all this while we were all in the all Switzerland, Geneva, Uruguay. Now we have come back to India, and we say that in India they have made the national IPR policy. Okay, the national IPR policy is coming under the DIPP, Department of Industrial Policy and Promotion. What does this policy do? Everything you write about dispute settlement, about international protection, okay, creating a proper environment for a policy to promote intellectual property. So DIPP is there. Okay, they have adopted under the Ministry of Commerce. So this comes in the Ministry of Commerce. They have adopted this policy in 2016. Okay, the goal of this is Creative India, Innovative India. So this policy has been accepted by the Ministry of Commerce, DIPP. Okay, India's regime. So this policy is complies with the WTO as well as TRIPS. Okay, the objective of this policy is to create awareness, to have a proper legal structure, management of IPR, okay, commercialize IPR, okay, enforce and dispute settlement, and human development, add in more staff for this. Okay, with this, okay, also this policy wants that with the India's proclamation that this decade will be the decade of innovation. So in this policy they have said that this decade will be the decade of innovation. Goals we have seen: generation of intellectual property rights, legal structure. We've done this above. Okay, with this we have completed the entire chapter, including the past exam questions. Thank you. Okay, clear till here everyone? Yes or no? I've completed every single chapter from your part B. Nothing will come outside. Okay, so I have completed all of this, and this order only you have to study. 1, 2. Okay, in this order only you can study. Okay, so 2, 3, then you go for this 4, 4, 5, and then in the last you do the 6. So 6, 1. This you don't have to do only. Okay, so 40 marks I have secured for you. Part A also I have given. I have taken a lot of chapters where you can easily pass. For more chapters, if you want, you will also get access to the Dream Batch. Study that, and that is it, guys. So wish you all the very best. Study really hard and complete your paper on time. Take care, guys. Bye. And don't forget to like the video, post in a comment of encouragement, so I feel more happy that I have been able to help you out.